So we do have a new member, so Karen, if you would like to have the board introduce themselves, that might be a start. And then Gary McGinn, our deputy city attorney, will introduce the council who will represent the board tonight, and then he can go through some training and different things like that. So.
Okay. So we have a new member of the Board of Adjustments.
Paul Crossett.
Say your name.
Crossett.
Crossett? Okay.
Crossett. Crossett.
I'm Karen Jeffries.
I'm Leslie Nelson.
Carlos Iglesias.
I'm glad you're here.
And
And Aunt Dameron is on the committee too.
What's your first name? OTT. Oh, okay.
so Karen, if you wouldn't mind giving Ott just a few minutes to let him explain why
Okay.
he's sitting in the back.
Right.
And then we can proceed with Gary introducing the council.
Well, you're probably wondering what's sitting over here. I have an interest in this topic here tonight. I've been involved in it from the start, even when you had your meeting down there at night at the holiday station. Well, yeah. And so anyhow, I've been there from all the public hearings and everything. So my plan is to recuse myself from any deliberations or decisions, certainly. So I won't be voting. I'll do that formally once we convene. But right now, I'm just going to be sitting there waiting.
Wait, so how can you recuse from discussions and still vote?
I
You
can't vote.
can't, you can't.
Oh, I thought you said you were going to vote.
No, I will not.
Just explain.
Misunderstood. Okay.
You just, basically just here, right?
I'm just here with the ears on.
Thank you.
So Gary.
I'm Gary McGinn, and I'm one of the attorneys for Orem. And I don't think I've met any of you. I don't think you've had a meeting since I've been working here. And so anyways, this is an appeal to the Board of Adjustment from a decision made by city staff to determine whether an application was complete and therefore vested under state law and the Orem City Code. Ultimately, we made a decision that it wasn't vested. So there's an appeal, Holiday Oil appealed to you. We didn't think it would make sense to have one city attorney making an argument to you about why we didn't think it was a complete application invested. And at the same time, another city attorney advising you on whether that city attorney was correct. And so we thought it would create a bit of a conflict. So we got outside counsel to come in. This is Ryan Wood. Ryan is the city attorney for Lehigh, and he will act independently of Orem City and Orem City's legal department, and doesn't take direction from us, and will be here to independently advise you in the hearing. Once you finish your dinner and those things, we'll go over to the council chambers where we'll actually hold the hearing. And Ryan will sit up on the dais, stand with you. And then if you close and decide to go into a closed session to deliberate, then Ryan would go in there with you and give you legal advice on what things mean in our legally and what you can and cannot do. Okay, and so with that, I'm going to actually turn things over to Ryan now. And as far as, if there's any questions or things like that you have, or procedure for Ryan will be answering those for you. Does that work, Ryan?
Yeah, and I guess just as probably to say initially, my role isn't to make the decision for you, right? My decision is to guide you to making a defensible decision. And that's really important to me, that you are essentially the judge, right? You're the judge in this context. It's not my decision. I want it to be your decision. Now, along the way, if you have decisions about, well, how does this ordinance apply, or what does this statute mean, or how is this, how does this word define, things like that, or, can we take a break, and how do we make a motion, those kinds of things. I'll guide you along that way and kind of talk about some legal things that might make your eyes glaze over, the standard of review. So, you're looking at the city staff's decision, and you don't have to give them the benefit of the doubt. You get to take a fresh look. It's called de novo. De novo, you can kind of pretend that they, doesn't matter what they decided, you're taking a fresh look, which is different sometimes. Sometimes the judge has to defer to a determination that the decision maker made. In this case, you don't have to. You get to take a fresh look at it. So again, I'll kind of walk you through some of those things. If you have questions, just speak up. Okay, but I'm your attorney here tonight. I'm not the attorney for the city of Orem. I'm the attorney for the Board of Adjustment. So.
What does vested mean in this context?
Yeah, and I don't know how much you want to get into substantive things.
But we probably shouldn't get into substantive things really at all.
Why are we in here?
To feed you in payment for
Thank you.
your time and service tonight.
But I have a question.
Yeah.
I wanna know what vested means.
Yes, and that is a great question. Let's just wait till the public meeting opens and then ask that one or any other, even general questions.
We can ask that in there.
Mhm. Oh, yeah, you bet. That's what I'm here for, so.
Well, then, I just wanna talk to these guys. If vested really means that the city is free therefore to just go ahead and change the zoning in the face of this agreement that they signed in 2020, then I think we should give.
Okay, but, so I'm gonna jump in for the first time here tonight. You don't wanna start discussing the issue right now.
And yet I do, but go ahead.
You want to, yes, but you shouldn't, right? Because again, the purpose of a public meeting is that, and I should say that as well, I meant to say that. So tonight, there's a difference in the law between a public meeting and a public hearing. Public meeting means the public has the right to come and watch the deliberative process. They don't have the right to participate in the deliberative process. Unlike a public hearing, and those of you that might attend city council meetings know, in like a zone change, right? In comes the public, I don't know how you do it, you give them their 3 minutes each or whatever, and they have the right to speak. So tonight, the only people that you're gonna hear from are the applicant and city staff, and that's it. No matter how bad one of the neighbors wants to come and give their opinion as to what this is the greatest thing ever, or this is the worst thing ever, it's gonna kill children in Orem City, right? They don't have the right to speak. So being a public meeting, though, we want to make sure that your deliberations happen in the public. They have the right to watch your decisions and to hear your questions, at least until we decide we've heard all the evidence that we're going to hear and we want to come back in here and discuss it. So that's why I advise you just not to.
That's okay, but Jason, it just seems like in previous meetings, and I haven't been in very many of them on this committee, but it seems like we did talk about stuff in this room
So
in previous meetings, so
maybe you can,
hence my faux pas.
maybe you can discuss, the variance is a little bit different process than an appeal.
Okay.
An appeal, you're kind of acting, like you said, as more of a judge,
Okay,
whereas a variance, do they need an exception to the actual ordinance? So there's a little bit of difference, and maybe you can address that.
And that's a public hearing in a sense, where people can comment, depending on your ordinance.
no, I just mean in this room.
And we do provide more additional information, we have a lot of more
I
discussion.
don't apologize, again, more questions the better. This is what I want you to ask, but so that you, again, it sounds like you've met infrequently enough that this isn't necessarily gonna be routine for you because you only meet once a year, there just hasn't been a need, so, yeah, don't be shy.
So
Just-
will that be explained, the difference between public hearing, public meeting in there so that people that are attending will know?
I think it would be helpful.
Do I need to do that or are you guys?
If you wanna do it, or if you wanna defer to me, I'm happy to do it as well, I'll just leave that up to you. Yeah, I was gonna suggest, so the agenda for this meeting actually says the public is invited to not just attend, but participate. You might wanna change just the way you.
Yeah.
Was there a letter sent out to neighbors in that area?
As a public meeting, yes.
A letter to them?
So just to be clear, we're deciding about an application that was submitted by Holiday that the city said was incomplete.
Yes.
And so they were turned down. And they're here to say, yes, we did do the application right. And they're gonna tell us why they did, and
Yep.
city's gonna tell us why that's what we're looking at.
You nailed it. That's
Okay.
it.
They're gonna say did to, we're gonna say did not. That's kind of the underlying,
Right.
there's a little more legal complexity to it, right? We'll go over with you. But he's independent, he's not controlled by us or directed by us. And he will give you independent advice, even if he says, you know what Gary was just telling you, that's wrong. If he believes that, he'll give that advice to you.
Who's paying him?
Lehigh City.
They don't know that yet.
And he's not receiving any money for doing this. He is coming in and doing this independently for the city. And
Is that why you're not eating lunch? Cause you're not getting paid?
me?
Yeah.
No, my lunch is over there.
Oh, so you are getting paid like I am. Lunch.
And we can bring sugar and donuts.
Sure, there we go, yeah.
Bribes.
And what is there, how did that happen? As far as inviting him, who invited him and,
I did.
okay,
And how that happens is when internally there is a conflict. And sometimes there are big conflicts and there are little conflicts. In this one, since the legal department was worked with staff, and it's the development services department, and this is a somewhat of a technical legal argument of the decision why the application was not complete. We thought it would look bad and just not be a fair thing to do, to have another attorney in the same office that's saying did not come in and give advice on it. And so we looked for someone who deals with land use law, municipal law. Ryan's been around a long time. He's worked at Provo City, advising boards and commissions on land use, zoning, development, contract issues. He currently works for Lehigh City as the city attorney and deals with these types of issues weekly.
okay.
And so I made that call. He agreed to do it for Orem City to step in and do this.
Just gives it a degree of independence, cause you have somebody, maybe a younger attorney in the office or something like that, may be reluctant to take a position contrary to what
The boss.
his boss or somebody has taken, so it's just better to have somebody come in. I don't have a proverbial dog in this fight, right? I don't live in Orem City, I've never represented Orem City, I don't know the applicant, and so I can be that more independent voice to help guide you guys to a good decision.
And Ryan doesn't mind hurting my feelings.
That's I'm sure that's true. Does he, question is, does he have feelings?
Let's not go down that road.
So there are some ordinances and codes referred to in here which I did not take the time to look up. Is this room the place to ask what those are, or do we have to wait to the next room to ask what those are?
Yeah, probably better in there, unless it's a very general question.
No, it's specific, what
Okay.
is this article?
Yeah, let's wait for those in
Okay.
there.
So I planned, or in my mind, we were going to be educated in here, but it's more in there.
Yeah.
I just wanna make sure I understand. Okay.
I mean, if you have, as the chair, if you have questions about, again, how to call for a motion or how to, those would be appropriate for you, but anything that has to do with the substance of what you're gonna hear tonight, because, and I don't even know if the applicant's here, but the parties have the right, again, under procedural due process, to hear those questions, to hear what guidance the board is getting. Again, I don't know, no matter which way you rule, this may or may not be the end of it, right? Your decision is appealable, and so they're gonna wanna know how you arrived at your decision so they can decide whether it's worth taking it to the district court.
So another appeal would have to go to the court situation.
I think your ordinance is the next I think the next step would be, well, maybe there was a provision that you could go to the city council if you wanted to, but you didn't have to.
Can we get an idea of who everybody else is here next month? Just all these folks, not familiar with that place. Okay. Starting on the corner way over there.
Hi, I'm Dr. Joe Barron, I'm the traffic engineer, and so if there were questions about the traffic study that was done.
You're Joe?
I did not understand some of those three-letter things. What do those mean?
I'm the traffic engineer, so I did the traffic study for the site. And so if there were questions, because I thought there were some questions regarding the traffic engineering that was done for the site, I'm here to answer the questions if you have any.
You're the one that originally did it?
Yes.
There's a TIS, that's a traffic impact study, and so they say TIS instead of traffic impact study. So that's one of the others that are.
Not trying to use acronyms, I'll try to spell it out.
I just feel like traffic dude.
Traffic
So
is-
you, I thought you said that you were with the city.
No, I am a consultant. It's hired by the applicant to do the traffic study.
When was the study done, what year?
The original study was done in 2020, and then there was done, the updated one was done last month.
Okay. Do we
The
have
original,
those
original one,
results?
I guess, it's.
They're all part of your packet.
Huh?
They're all part of that 200 and whatever page.
400.
400 page document. We've all read every word of.
And I'm Brent Neal with Holiday Inn. I'm the one that's gone through the planning commission. and city council.
Okay, all right,
It's on
awesome.
your name, okay.
All right. And my name is Mike Wagstaff, I'm one of the owners of Holiday.
When Cameron Duncan with Enzyme Engineering, we did the civil engineering to help support them in their civil process.
I'm Robert Mansell, I'm counsel for Holiday.
Okay. All right, so we got 3 attorneys here. Oh, 4 attorneys.
No, he's not.
My name's Scott Wagstaff,
Okay.
owners of, my brother.
Got lots of love for all the attorneys. I wanna see that happen out there.
See, I don't have to fight, I'm on your side.
Okay. Good to know.
You know Matt, and then Grant with the city.
So really, I didn't understand some of those three-letter acronyms. I figured some of them were westbound lane, but can you
So-
just run through?
Well, so again, I think what you do when we get in there,
We can.
you just call him up to the podium and you ask all your questions.
How's the weather?
Now you're going down the right track for this room.
Wow, okay.
Sure. Said that, shouldn't we?
Yeah.
So we talked about it, I asked about packets of information and
Yeah,
so I get it tonight. I haven't got.
You didn't get the
first.
So you link at the bottom of
the
the
packet?
email, there's a link.
So that's probably.
Maybe if you click it, you have to try and figure out where else to go, and then you find it.
But they should have warned about work session meetings and just go down the date
When did you send that?
a week ago.
So
Yeah, we always say about a week ago.
Karen, what might be appropriate to talk about is just the procedure. Do you have an idea of who presents first? Do you want me to kind of tell you
That
how
would be
things?
really
Yeah,
helpful,
no problem.
yes.
So typically in a hearing like this, we kind of act like a public, in a meeting like this, like a hearing in front of the city council. I would recommend that you let the applicant go first. If it's the applicant's appeal, then we can hear from the city. And then give the applicant, a few minutes to kind of as a rebuttal. Then kind of, you don't have to close it like you do and close a public hearing, but then bring it up to the board. And let the board ask questions when the person is presenting. But then when the presentations are done, give the board another opportunity to, again, maybe questions have come up. To ask of the applicant or the city or of me, clarifying things like that. And then at some point, you'll either be, and we can kind of just play it by ear, you'll either be comfortable making a decision right there. You may wanna come back and deliberate with me and go out and make the decision, or you can take it under advisement, or we'll just kind of see at that point what you're comfortable with. You have all the information you need, then you can go ahead and
And
make
you're the one that will be advising.
Taking it under advisement, is this,
And we could issue, I mean, you don't have to make a ruling at the end of the meeting. You can take it under advisement, we can deliberate, then you can direct me to put it in, I mean, I'm gonna put it in writing anyway. But you could say, okay, we can still make the decision, and then you can tell me to issue it in writing to, to the city and to us. Unlike a city council meeting, again, because you're a court-like, called quasi judicial, you don't have to go out and actually make the decision in front of everybody if you're not comfortable doing that. Sorry, you had your.
I just have a request for people who are coming to the podium to speak. Their name and your lip and sign engineering or.
Yeah, and that would be, Karen, you'd wanna do that, as every person comes up, if they forget to do that, just remind them to get there. What information do you want, name and?
name and
Just
who
a-
they're,
Okay.
My city or
Yeah.
and sign engineering.
Do they all have the same file that we have, like the 450 some pages?
No.
It's all public.
It's always publicly posted, so I don't, it's not always sent to
We
the.
send emails with the link, right?
So it's the orem.org/meetings and it's just the same link you got.
Yeah, that's what I got, I just wasn't sure if they were actually sent that information, or if people can find this information.
well, someone can submit it.
But a little advice.
Right, it's just the whole packet that you guys just compiled all their information, the city's
Correct.
information, yeah, for us, I just.
One thing that can be helpful, again, Karen is the chair, and for the board members, if you have a question, just to kind of keep things organized, if you'll ask permission of the chair, Madam Chair, may I ask a question? And then you acknowledge, just so we don't have three people trying to talk, or two board members talking to each other while somebody's engaged with the person at the podium, it just kind of maintains decorum and order, so. It's just a good practice to ask permission of the chair to ask questions. And it makes you feel really
That is
important.
very different, but that's okay.
You don't
If you guys have
you
any
don't have to do
iPads
it.
or anything, tablets,
Different than what we.
see if you can just pull it up, just so you know what we're looking at. And you strike me down if I'm speaking out of turn, any attorney, But it is on the Orem City, where's it?
Orem.org/meetings.
Meetings.
Since there's still 20-some minutes, they can at least kind of.
The legal opinion, I'm assuming, is part of the packet.
I'm sorry,
Was the legal opinion written by Jake part of the packet? Yeah.
yeah, I believe it was.
So, sorry, was it Robert?
Yes.
Did you have access to, there is a legal opinion as part of the packet information?
I have not seen it.
You might want to take a look at that, so. Your letter is part of it, and
Yes.
I've looked at that, but there's also a
Memo.
legal opinion from the city attorney's office that you might wanna glance, I don't,
It was in the packet.
yeah, it's in the packet.
It's pages 214.
I mean, it's similar, it's just an expanded version of the basis for the denial, so I'm sure you've got a good grasp of it.
200 what?
214 and 215.
Oh, I thought you said 14.
Do you know where?
That was fast
2
reading
to
for like
14.
2 days.
214 and 215.
Yeah, it's a big packet, so
Well, that, I,
mine had links on the left side that you could click on it.
Yeah, that's what I was saying.
Yeah.
oh, one of
links to
215, maybe that's.
Oh, yeah,
Probably
yeah.
not good. Is there-
So
that's why I got it.
you can type in there.
Yeah, we run. Sorry.
Other one.
Oh, this is Ryan Clark. He's do you know what the Wi-Fi password is? I should know that, but I don't.
You shouldn't feel unforgotten.
Oh,
There we go.
you can just.
Maybe that's not it.
Oh.
So 215.
It's
Yeah.
very nice. Mhm.
Whoop,
Sometimes it's like.
and then the other one.
It used to be when they were like, the way we were, the ones were.
I know, but I.
They just run with the speed.
Clearly.
Oh, well, that makes sense.
Well, I printed it, so here it is.
That's it, that's what I was looking at,
Oh,
right
is
there,
it? Oh, okay.
that's
Yep, that's it.
Yep, that's it.
Yep.
Like similar, and if they didn't, that's a problem, that's not.
I just picked up this stuff.
You can lead a horse. Can't take a drink.
I guess we don't have to put stuff up.
So here's the.
Just one.
Put up an Adobe.
And the version on, hopefully that has links, so it's really easy to click.
Oh, and I think I downloaded it. So right here, summary of facts. That's on like page 7.
It's 2020.
Sounds like they're fun. This was all sent.
Yeah.
Just page or
They were
two.
reading that earlier this
Yeah,
morning.
see, so what
But
you
it
should have
wasn't, it's
this is or a link. You click on it, bring up the PDF. You go through that little summary, and there's a couple of pictures, what's some showing property. And this goes into this, and this is. And then it's,
Wasn't permitted.
you know, just different exhibits, reasons.
Yeah.
Yeah, and the development.
That's getting.
So it's just.
How's that?
And that's it.
Yeah, it's about, so.
That's a question, that's a good question.
In your argument. Give me some of
That's his job. That's his job. I might need to go to the actual link from the website, this one. What's the link? Orem cities.
Link to That's easy. It's like, you didn't have a real thing. So it's kind of a quick procedural question. That is what they do. So, this is it.
what's going on.
Yeah. But it's not, you can't, planning commission, but they're quasi judicial. Actually, you gotta think of it now.
Subjects that I want.
Judge you, you're on the
Those pages.
They don't have to. It's just. It's legislatively, legislative, because you absolutely have to. Right. Wasn't judicial.
Here's, now this is interesting. That's, there's some reason that's. And I don't. Yeah. When you follow the link, it has those quick links on the side. And I had downloaded that online.
So I can't even get to your website right now.
So here's the first
Yeah.
On the right.
Yeah, but like.
He does, he signed it for gas.
On the actually, so it's not.
Yeah, so you can't reach. Sorry about that.
So I have this up already on my computer, but it's. So then I tried to use the website.
Newer standard Wi-Fi.
I can make a big difference on downloading, right?
Got 5G right now.
So something about it's not working. And I don't know our internal. I don't know. Well, I printed off, I thought that it's just, you know, I don't have a full small code. Maybe look up a word. But I could do it on my phone if I had to.
I just, when I heard probably just.
Yes.
So she goes,
Well.
you're on an iPad.
So we get in there.
Jason. Familiar with where to find downloads on an iPad, so I'm change that. I haven't used one of these.
Hey, Ryan, the burden, just so I understand the appearance of the process of any, the burden is on the applicant to prove, to show cause if there needs to be. Kinda or no?
Is that the case for the appeal?
Not so much in an appeal.
Okay.
Okay.
I mean, so generally speaking, the way we look at it is, what does your decision need to be based on in order for the court to uphold it? It's not so much, you know, beyond reasonable doubt or preponderance of the evidence or anything like that. It's basically, you get to interpret statutes without deference to however they've been interpreted by others. You get to make factual determinations regardless of how they've been made by others. So your decision will be upheld if it's basically, the standard is, what is it? Substantial evidence. So if there's substantial evidence in the record to support your decision, then it should survive the next appeal. Begin with that, yeah, so, and the way that we'll do that is just making sure whatever your decision is, it's based on findings. And so that's really my job, is Whether I personally just think you've made the best decision or the worst decision ever, my job is to just help you make a defensible decision. You guys get to make the real decision.
Well, we all accepted this knowing that we're gonna have friends after a meeting and not have friends after a meeting.
That's why most city council members don't last more than 2 terms, because they
Yeah,
tick off enough people after 8 years that nobody wants to reelect them.
that's why bishops have 5 years.
That's right.
Said no to me.
Start saying no.
Oh, there it is. Where?
Right here.
It's on that page.
Yeah, that's the page, let's see.
It's just finished down.
Just let me know.
Maybe it's good for the little bit.
My number 2 kicks this.
Sorry. Yeah.
So it's kind of half and half.
There's denial about. Is this it?
Yeah, I like critical, that was really high, so I think the one I liked it then, I haven't had any much experience with things, but position was kind of half prosecution.
You know, we're all fine.
Half
The
planning
definitions,
commission.
it says
I
400
think I think
pages.
it's Jake prosecution experience. That's the only other, I just don't have time to train. So Craig had done the same thing in Wasatch County prosecution. Planning commission. A little bit better, but if I had heard decisions on Craig or Jake, like that. Yeah.
Well, I've tried that before, well, I guess
The doc, I submitted a letter, it is in the doc.
I think it's at page 210 or something like that.
Okay.
no, see, I couldn't do it at that point.
You can't?
Right there, because it was, well, I was looking at it.
And it's not.
So if you put it in the I thought I did it. Well, it's loading.
Oh,
Yeah, no, it's right here, because then you'll be fine.
Tell your brother Dave hello for you.
I will. He's having fun in Kentucky.
Is it?
Yeah, he got to go to Rupp Arena and watch a game. So Bob's got
There you go.
recuse himself. So
You behave like
and then she's gonna do the city thing.
It's your house.
His support. We got our Chinese wall right here.
There it is.
No worries.
I'm glad you didn't feel pressured to do anything. Okay. Gee. I thought we were gonna do in the chair. Seriously, because they. It's 6 o'clock, so we'd like to start this, I call to order this meeting, the Board of Adjustment for the City of Orem. I've asked Carlos Iglesias to give us an opening prayer before we start.
Our Father in heaven, we are grateful today to be here gathered to meet on this Board of Adjustments meeting. We're grateful to serve and to be able to have some discussions and to take these concerns and matters and to deliberate and understand. We ask thee to give us inspiration that we may work together and understand each other's positions, and that we may do it in a civil manner. We say this in the name of Jesus Christ. Amen.
Amen. Thank you. This is a little different for a little different format and a little different agendas and items that we're considering today as a Board of Adjustments. And so please be patient with us, okay? We'll do our best. And we want to appreciate that prayer, and we're willing to be here to serve. So that's what we're trying to do today. All right. We need to. Oh, yes. I'd like to give Mr. Dameron a moment to explain his position today.
Good evening, everyone. I'm grateful to the chair, Karen Jeffries, for allowing me this time to make a statement to the board and the audience concerning this application. My thanks to her and my colleagues. As you can see, I have the same last name as the couple who has led the charge in opposition to this application. They are our son and daughter-in-law, and I have to say that I'm not unbiased in this case. I have followed the process and supported them along the way for months, not knowing that the application would end up here at the Board of Adjustments, which I served on for about a year now, I think. Therefore, I must recuse myself from this meeting tonight, from discussing and certainly from voting on any resolution to this problem. So that's what I'll do. I'll recuse myself and wish you all a Merry Christmas.
Thank you, Mr. Damron. Appreciate that. Okay, item 3.1. I've lost Mr. Bench. Where is he? Oh, there he is.
He's been put in the back.
Right. Will you be introducing the item?
I was not planning on it. If you would just like to read it and then have the applicant present his,
All right.
I'd be glad to help any way I can, but we're just going to have the applicant present his side and then the city present their side, and then you can do the deliberation.
Okay.
But if you want me to just start with, this is an appeal by Holiday Oil appealing the staff's decision of whether or not it was a complete application. And that's why they're here tonight. So.
Okay, thank you.
Madam Chair,
Yes.
did you want me to say something about the nature of this being a public?
That would be wonderful.
Okay.
Yes.
And maybe the audience has already been educated, but different than a public hearing in front of a city council where the public has the right to speak, this is a public meeting. Okay, so the Board of Adjustment will hear from the applicant and then from the city, but won't take public comment. So thanks.
Thank you. And this is Ryan Wood, who is his attorney that's helping us tonight, and he is from the Lehigh City Attorney, right? Okay, thank you very much. All right, so we are here to hear the appeal from the applicant requesting that the Board of Adjustments make some changes or accept an appeal pertaining to the City of Orem's determination that the applicant, Holiday Oil, their DRC application is incomplete for Holiday Oil gas station and the convenience store generally located at 1981 South Geneva Road in the C2 zone. So we would ask the applicant to come and state their case. And we would appreciate that everybody who speaks tonight, that you'll state your name and your affiliation, who you represent. Okay, is the applicant here?
Yes.
It looks like we're trying to decide who. Okay, thank you.
We'll make that decision for you.
Good.
Good evening. Thank you very much for taking your time this evening. My name is Robert Mansfield, and I'm with the law firm of Mitchell, Barlow and Mansfield, and I'm legal counsel for the applicant Holiday Oil. You're going to hear from a couple of us tonight. This deals with a few different issues, and want you to get the full spectrum of what's going on here. I understand then the city will have an opportunity to speak to you, then we'll have a few minutes for rebuttal.
Yes.
Obviously, as you discussed a little bit in the work session prior to this meeting, you were overwhelmed with a 400 page packet of information. There's a lot there to read. But with that, let me give a little background so you're kind of aware of what's happening here. Originally, as you noted, this property is located at 1981 South Geneva Road here in the city of Orem. Originally, this property did not have the C2 zoning, but had an OS5 zoning that would not have permitted this proposed gas station and convenience store. Through various efforts, a development agreement was reached with Orem City, with the prior owner of the property, that allowed this property to be developed for the gas station and convenience store on certain terms and conditions. Limits were placed on the owner of that time as to what could be done with it. It couldn't be fully developed as it may ordinarily be done within the C2 zone, but in consideration for that, the Orem City agreed that it would consider a zone change to C2, which in fact was considered by the city, was done and was passed, and this property, the zoning on this property was changed to a C2 zone. But because of the development agreement, that somewhat limited the full extent of development that could be done by this time by Holiday Oil, who acquired the property and received an assignment of the development agreement. So they stepped into the shoes of the prior property owner and have the same rights under the development agreement as that prior property owner did. And this allows, and if you've seen the development agreement, this was dated December 8th, 2020, and it had concept drawings attached as Exhibit C that provided what could be done. Now, subsequent to this agreement and prior to the application we're discussing now, Holiday City came into the city of Orem to seek an amendment to the to the development agreement to also try and add a car wash to it. That's a typical amenity of many of its filling stations. The city didn't want that. And Holiday Oil recognized that and abandoned those plans for the car wash and went forward with the what was permitted under the development agreement, which was the convenience store and the gas stations. There were limits put on the hours it could be open, lighting requirements, the number of pumps that could be there, a prohibition against large trucks receiving diesel fuel. Any diesel pumps had to be limited to small trucks or vehicles. And there are other restrictions placed on Holiday Oil as to what they could do within the zone that may otherwise be permitted within the zone. Now, you've also received in your packet the legal opinion letter from the city of Orem talking about the development agreement and the fact that this did not limit their police power. And that is true, but let me explain what that means. So if you look at paragraph 8 of the development agreement, it says no limitation on exercise of police power. It says nothing in this agreement shall limit the future exercise of the police power by the city in enacting zoning, subdivision, development, transportation, environmental, open space, and related land use plans, policies, ordinances, and regulations after the date of this agreement. Now, I'm sure you'll hear a contrary point from the city, but what this means is they reserved unto themselves the right to make changes, but if they make changes that decrease the rights of now Holiday Oil, that in essence is a taking of property rights. And that would then, even though Orem City would have the right to make those changes, that then would give the applicant a right to come in on an inverse condemnation suit saying, you have taken rights we have. And that's, even though they have the right to make the changes, they are still subject to those restrictions under Article 1, Section 22 of the Utah Constitution, which states that no property may be taken or damaged without payment of just compensation. Now, I think so pursuant to the development agreement and the discussions with the Orem City staff, Holiday Oil submitted its application for development of this gas station and convenience store. They went through the initial process, and we'll get more into this in just a moment here. And Ensign Engineering, who was engaged by Holiday Oil, will address some of these issues. It's typical in the development process that you get what's called red lines. You get responses back from city staff saying, this wasn't addressed as much as it could be, or we have a question about this, you need to address this, you need to address that. There's several things that need to be addressed. That is a very typical process a typical thing to happen within the development process. And that occurred here. There are a number of red line items, but when it came to the transportation issue, the only question that staff had on this was this submitted to the Utah Department of Transportation? UDOT has to give approval here on states Geneva Road, because that is a state-owned road. And so UDOT also has to comment on access onto Geneva Road. Nothing was ever said, no red lines whatsoever, that the traffic study, and there's been some terminology, I heard that about TIS, the traffic impact study, that was insufficient or unreliable or any problems with that. In fact, there was a letter sent out by the Orem City Council, City of Orem Mayor and City Council, a letter dated August 28th, 2023, and it's sent to the neighbors of this Holiday Oil site at 1981 South Geneva Road. And it says, dear neighbors, we want to provide you with an update on a new development with the proposed Holiday Oil project at 1981 Geneva Road. As you know, the Orem City Council strongly opposed the project and took aggressive action. This included denying a request by Holiday Oil to amend the existing development agreement The council also proactively started the rezoning process. The council was working as quickly as possible to complete this rezone to prevent the project. Unfortunately, Holiday Oil submitted a complete application on August 21st, 2023 for a site plan that is consistent with the existing zoning regulations. And as a result, Orem City had to accept the application and will have no other option than to approve it if the city process is followed. Now, the mayor and the city council are not going to come up with the idea that this is a complete application on their own. This obviously came from city staff saying, yes, this application was complete. And what should have been done, and what was done in other circumstances, even here in the city of Orem with traffic studies, if you had issues, you got red lines that you had to address. And that's the process that should have been followed here, but wasn't. But what happened here is there was a rush and there was gerrymandering done in order to prevent this Holiday Oil site from being erected, being developed and constructed. This was an end run around the rules. And what I'd like to do now and talk a minute, have Ensign Engineering come forward, tell you a little bit about the process, what happened. Then you're going to hear from the traffic engineer, Dr. Perrin, Joseph Perrin. He'll talk, he's the one that performed the traffic study. Also, as a result of the subsequent, after the mayor and city council said it was a complete application, then Holiday Oil received information from staff saying, no, the application was incomplete. It's being denied because it was incomplete. Based on that, Mr. Perrin updated his traffic study to provide, and that was submitted to the city of Orem, and Dr. Perrin will discuss that for a minute. And then I will come back up and give you a quick summation, and then you'll hear from the city.
Great, thank you. I'd like to thank you as well for serving. I know it's kind of a big deal. I've had the opportunity to serve on the planning commission in my city for 5 years. And so I know what it's like getting paid in dinners, and I'm always grateful for those. So I think kind of where I want to take it is not so high on the legal kind of jargon, but just kind of what does it mean to be vested, right? And why do properties want to be vested? So in the state code, it reads, an applicant who has submitted a complete land use application as described in subsection 1C, including the payment of all application fees, is entitled to substantive review of the application under the land use regulations. And if you go down to 1C, it says a land use application is considered submitted and complete when the applicant provides the application in a form that complies with the requirements of applicable ordinances and pays all the application fees. And that's our position, is that that's what we did, right? So we made our application, our initial one, in August. And at that time, we got an email from staff, and it said, hey, you're missing your geotechnical report and a percolation. That kind of talks about the soil and the water table. So we had that, we just hadn't included it. So I included that and I got it sent off. We waited a couple of weeks, and then we got a first set of red lines back. And the red lines had a significant amount of comments in there, and that's very typical for the process. So we had a handful of red lines, general stuff from the water department, stuff from engineering, stuff from planning, and all those kinds of things. So we corrected those red lines, addressed all of those, and resubmitted those plans. And we got them turned in, and that was on September 5th, which was the day before the planning commission meeting. And we got that turned in, and then we were waiting for a second set of red lines to come back. That was the one that the attorney addressed, that there was only one comment from transportation that said, hey, have you submitted this to UDOT, and have they approved it?
Can I ask everybody to tell us the year as well? Because you say September 5th, and we have so many dates and we're new to this. So is this year
Yes,
2023?
Yes, this is September 23.
Thank you.
Thank you for that. And so we were waiting for another set of red lines, and then that's when we got notice that said, hey, your application is incomplete. So I want to go back 2 years to 1920 or to 2021. Sorry, I remember the 1900s. to 2021. And we did a previous Holiday Oil in Orem City, and that was over on 1500 West. If you guys are familiar with where that store is, what south is that on? 8th North and 1500, 8th North, 1500 West, right? So on that particular submittal, we submitted and we provided everything on the application. We paid the dues. The city gave us red lines. We addressed those red lines. They gave us a second set of red lines. Sorry, let me go back. On the first set of red lines, we got comments from the transportation, and there was about 14 comments, half of those addressing our transportation impact study. On the second submittal, we got 4 comments back from transportation, some of those, addressing our traffic impact study. On the third set of red lines, we got 2 comments from transportation. So that's a very common way of going through that process of getting those reviews. So we were a little surprised when we didn't get any comments. And then all of a sudden we got that back. So it's our opinion that we did submit it, that we were vested based under the definition of state code and have the right to move forward, similar to that letter that was presented by the mayor and the council. I think that's all I have. Anything else you want to add?
Madam Chair.
Whoops. Yes.
So what does vested mean?
Okay. So my understanding of vested, so the applicant or the property owner has rights to develop the property based on some restrictions that the city puts on it. Usually it's based on zoning. And so on this, they had a right to build a gas station. They didn't have a right to build a car wash. So we provided all of the engineering documents based on the requirement from the development agreement from 2020. And then based on Utah code, it says, once you've provided that information and the city accepts it and you pay your fees, now you're vested. That means you have an inherent right to move forward underneath those requirements. One of the other things that we deal with a lot is the building code changes about every 3 years. So if you submit an application before the building code changes, even if it's 1 day before the code gets adopted, it's reviewed and constructed under the original building code, not the new adopted building code. And so the same thing here, we would have to design that based on the codes that existed on the day we submitted, not the new codes. So if the city changed their landscape ordinance and said, instead of a 20-foot landscape buffer, you need a 50-foot landscape buffer, if you submitted before that ordinance was enacted, then you would design it under that 20-foot, not the 50-foot landscape buffer, because you have those vested rights. Does that help? Great. Any other questions for me before I step down?
May I ask a question of the speaker?
Yes.
I'm sorry, I forgot your name already.
Cameron with Enzyme.
Cameron.
Yep,
Thank
with
you.
Enzyme.
Who notified you about the lack of the geotechnical report?
It was staff. It was Cheryl.
Okay. So it wasn't the DRC.
I don't know how it works internally. It was Cheryl's kind of been our contact that we've worked with as we've submitted stuff.
Okay.
A question?
Yeah, Ryan, can you just
yeah,
give
I'm
us the
sorry.
definition of vested?
Yeah, he did a good job.
Is that
Yeah.
okay?
Yeah,
Okay.
if I'd said it simply, I'd just say it locks the rules of the game into place. So whenever your application is considered complete, whatever the city's rules and ordinances are, that's what you're entitled to proceed under. So they can make changes, but they'll only apply to projects moving forward, not those that have already been submitted and considered complete applications. There are a couple exceptions to that we won't have to deal with tonight because they're not at issue, but that's the general rules that locks the rules into place.
Okay. Yeah, kind of like
Yep,
you're
question two.
grandfathered under that.
Yeah,
that
that's
section of the
that's the
ordinance.
term we use a
Yeah.
lot as grandfather.
Right.
Yeah.
Great. I'm happy to come.
Cameron,
Go ahead.
so the development agreement, that was part of the original zoning change to the C2 before you were involved.
That's correct. That was in
That was the
2020.
previous owner that got the C2.
Yes.
And
then-
with that, there was a development agreement. And that development agreement did not cover everything Holiday Oil wanted to do, or did it?
So the original one, the the original one, they had provided a site plan and an elevation. So they said, the building's going to go here, the pumps are going to go here, the driveways are going to go here, and this is what the building's going to look like, right? So it kind of gave those parameters that you see when you drive down the street, which is very common. Holiday wanted to change it. They have a different building type. They also wanted to add a car wash. So that's when they came back and tried to amend that development agreement. They said, hey, we know this is what we agreed to, but we would like to tweak it. And that's when the city council said no. That was that September? April? Yeah, August of this year. Yeah, of this year. And so once they said, no, you can't do that, then we pulled together a full set of plans of all the engineered drawings, site plans, grading plans, utility plans, a new floor plan and elevations that matched the development agreement from 2020. And that's what we provided to staff.
And at that point, is your position that staff did not accept the application, or is that a different date?
So it's our position that staff accepted the application because we paid the fees, right? And then a couple of weeks later, we got our first set of red lines that came back that said, hey, we want your water line to connect over here. We want your water meter to be this size. We want your catch basin to be Orem's typical standard instead of a different.
So you made the assumption that
Sure.
because you got it redlined.
Yeah,
it's
we
been
were
accepted.
well into the review process.
Okay, thank you.
Yes.
That's good.
And we had a lot of comments from all the departments except transportation. And they just wanted to see that we had submitted it to UDOT, which we had. So thank you.
Hello, I'm Joe Perrin with A-Trans Engineering. I did the traffic work. We did the original study back with the previous owner in April of 2020. And I guess just the process has been taking a while. So what ended up happening is that same study, I think, had been submitted as part of this package originally in August. And again, the comment that came back was pretty much, this is old, we need a newer study, which we updated and was provided in October. According to your senior transportation engineer, he has not seen that yet to review. So that's the status of that report, is pending, I guess, for the updated study. Other than that, it meets UDOT standards, it meets your city standards. Both reports do. The difference was just that it appears that the 2020 report was submitted. It was considered old because a traffic signal has been installed at that location of Geneva in 2000 since the original study was done. But both of them met the standards of the time. Not sure why it wasn't updated before the application went in, but it has been now. And really, I'm just here for questions to see what exactly, because the transportation seems to be an emphasis here. Thank you. I guess the key point is that it has been said that these were unreliable, and I'm not quite sure what that means because we've never seen any red lines. They are reliable. They're still valid. It's just a traffic signal had been installed, which was one of the things that had been recommended in the original study. And now this updated analysis includes that. So again, the reliability of the studies is where I was kind of here just to defend my name more than anything. When people say something about my work, I like to make sure I can stand by it, and I do. So there were some questions that I believe you wanted to ask me. Oh, sorry. Yes.
So to be clear, the study was performed for Holiday Oil.
This latest one, yes. The
And
original one was the previous owners.
Okay.
Before Holiday Oil was involved.
Okay, and you're representing both. You represented both parties as developers, basically somebody that was wanting to rezone property, and you were doing a traffic study to say this isn't going to impact the traffic and it's not going to affect people's lives. I mean, what parameters are you trying to satisfy with what you did? What
So
do you-
the purpose required of a traffic study to get an access is from a UDOT standpoint, they require it. They have very, very defined categories and methodology that you must apply so that they can identify the analysis, the access functionality in the nearby intersection. And then if there's an impact, then is there a mitigation that would go in as part of that? And so in this case, originally, the mitigation was it's time to put a traffic signal in Geneva Road. So that was the 2020 study. Since then, the signal has gone in. So the update of that has been to recommend some additional left turn phasing. So right now, they don't have the flashing yellow yet. And so we have recommended that that be a betterment at that signal to mitigate the impacts of the traffic. But the purpose of the study is, and it's always at the applicant's expense, that they hire a licensed transportation engineer to do a traffic impact study so that they are able to quantify for the city and the state what those impacts are and what the appropriate mitigation is.
Okay, and so being independent, are you if you're independent, are you representing the people that live there, or are you representing the developer?
I do the traffic analysis at the direction of the developer,
Okay, so-
meaning the developer pays me.
And I don't know, this is just something I'm thinking about. 2020, what's the time frame of COVID during that original study?
And that was pointed out in the study, in fact.
There's
that
an
the data was
asterisk that
collected
says,
during that.
this is what I have, but it may not be reliable because we don't have true numbers, or what?
No, it uses an adjustment factor that UDOT had approved as their COVID adjustment factor that's applied. And so essentially what we say is this is the best that we think it used to be based on historic data and what the traffic had been there. But the actual individual turning movement counts are what they are. We have to go out and physically count those. And at the time, we didn't know how long COVID was going to go on. So things continued. And so we use adjustment factors. And UDOT actually published those adjustment factors based on the region and what they were identifying from their permanent counter locations throughout the state.
So how does that relate to that street? I mean, COVID, and I'm just looking at it like making sense.
Yeah.
COVID is something we've never dealt with. So how does an organization put a factor on what it's doing to impact a neighborhood or a road where you're going to pull out onto the light is probably a good addition because of the speed that people traveled that curve.
Right.
But I'm just trying to make sense in my mind of
how they did that.
Yeah. How can they give you a number that's real?
It's the best estimate. So again, what they have is permanent counters out there. And so what they have is every hour they're counting cars at
During the
certain
study.
locations. It could be on the freeway, it could be on Geneva Road somewhere. But the idea is that from those, they can make adjustment factors. So they know what their history of that road has been. They can see what it has reduced by because of during COVID. And so what they're able to do is come back and say, you need to add 30% more traffic if you want to get back to the pre-COVID levels type of thing. But it's not specific to every single road. It's more of, here's what we're noticing in this area at these locations. So why would we think it's any different?
That
at
was
that
part
specifics?
of the original study.
Yes.
That was relayed to the people making decisions.
It stated in there that this is COVID counts and that there needs to be some consideration for that. Yes, that was in the original study. But again, as that went through, and so studies are usually good for about 18 months. And then we consider, hey, let's go out and get some new data. So it's appropriate to ask for an update for sure. It's just, it wasn't asked for until this latest round.
So I'm assuming then that the update that you said happened in October of 2023 would reflect what's currently the situation, not 2020 then.
Correct. That 2020, that's what we did when we did it in 2020.
Right.
2023 run out brand new counts, fresh counts, making sure school's in, et cetera. The typical data collection days are Tuesday, Wednesday, or Thursday of a non-holiday week. And that's what you collect your data on, because those are representative, because Some people take Fridays or Mondays off, so we try to get that middle of the week. And those are counted from 7 a.m. to 7 to 9 a.m. in the morning and 4 to 6 p.m. in the evening. And those are considered the peak times and what's required from a data collection standpoint and that period, so that you're measuring what is typically your worst part of the traffic day.
You mentioned that the city doesn't have the update yet, or I'm confused about that part.
I believe that.
Do we have it?
I believe it was turned in. I just talked to John though, just before this meeting, and he hasn't seen it. And he would be the one who reviews it for you. So I don't know where it is, but
Okay, so
he
that's
actually
why
asked
you
me
made
to
that comment.
email it to him in the morning.
Okay.
But I don't want to supersede any process.
Yeah, we can
That's
ask
my
him.
biggest-
Did you have, Madam Chair, I have a question.
Yeah.
So I spent 4 years on the Traffic Commission and I learned enough to sound like I know what I'm talking about to
Everybody with
other
the
people
driver's
who
license.
haven't been. But okay, so I think it would be helpful for you to explain to us what I think I understood from the traffic study that I saw when it was talking about a level of service being A, B, C, D, or F. Was there an E in there? I
There's an
can't
E too.
remember. An E or F.
Yeah.
And it seemed like with the mitigating factor of the traffic light that's there, that it seems like it's a pretty high level of usability in that area based on your study. But would you be more specific?
Sure.
Thank you.
So just to go back.
And
to
by the way, I don't have it in front of me. We aren't able to show it. And plus that, I didn't understand all of it. So it would be helpful to hear what your point was on this thing.
Madam Chair, may I ask a question that might help, right? To put your minds at ease that you don't have to be traffic experts. And maybe this
good.
is for Mr. Mansfield. Does the applicant object to the conclusion that the traffic study needed to be updated? I don't want to put words in your mouth. I assume you would concede that it needed to be updated. But the issue on appeal is whether the lack of the update meant that the application was incomplete, or it would just simply needed to be part of the red line development process. But I don't want to speak for you, so.
No, certainly, yeah, let me address that. So when the approval was given by Orem City in 2020 for the development agreement and for the location or for the placement and development of the gas station at this location, a traffic study was required to be done. And Dr. Perrin is the one who performed that traffic study. And Dr. Perrin can go into it, but the level of services were acceptable with the gas station being built. Use of that traffic study in the application that was submitted by Holiday Oil does not deem the application incomplete, but that would subject Holiday Oil to red lines and comments and requests from city staff to update that if city staff felt it was advisable to update it. But as Cameron was saying, when they got the red lines back, there was no request for an update to that traffic study. The only question was, have you submitted it to UDOT? But had city staff wanted an update to that, then yes, it would be required and incumbent upon the applicant to update that.
Yeah, I bring that up only because I don't want you to think that your job is to review the quality or the technical appropriateness of the traffic study, right? The issue that's before you to decide was the city entitled to require that before they considered the application complete, or was the traffic study that was submitted as part of the 2023, again, based on the 2020, but part of the 2023 application, enough to say, okay, this is complete. Now we want, just like the other process of red lines that came back, should that have been the city's responses? Well, here's another red line for you to address. Or was the city justified in saying the lack of the update means that this application is incomplete? Does that make sense? So you don't need to worry about whether it's correct or whether it recommended the right traffic signal and a flashing yellow light. Your job is to decide whether the city was entitled to say, nope, until we get that, your application is not complete, or no, what you did in 2020 and submitted as part of 2023 is sufficient for us to say this is complete. Now, we might want to send back a DRC might want to send back a red line comment to get some updates, but it's complete for purposes of moving forward and being vested. That's what you're deciding tonight. So.
I think all that makes sense, but we had to read 215 pages, and so I'd like to know what it meant.
Sure.
Too much.
Yeah.
I have a question about the ownership of the property here, because a couple of times this has been mentioned, the previous owner and now Holiday Oil. Who was the one that authorized this traffic study, or not authorized, but, had that?
Engaged
performed?
traffic study.
Yes, there you go.
So originally with the 2020 zone change and development agreement, the prior owner of the property, who's listed in the development agreement as Lane Taylor and Cynthia Butler, trustees of the Lloyd Taylor Living Trust, Donald Kent Roberts, an individual, and Axley Way Investments LLC were the owners of the property in 2020. They are the ones who engaged Dr. Perrin to perform that traffic study in connection with obtaining the development agreement and the zone change to a C2 zone. Does that answer your question?
Mm-hmm. And then Holiday Oil was just able to use that traffic study.
Yes, Holiday Oil, by acquiring the property and receiving the assignment of the development agreement, stepped into the shoes of the prior owner.
Okay.
So really, for all intents and purposes, it's the same person.
Mm-hmm. Well,
and then now going forward, Holiday Oil has the rights under the development agreement, whereas the prior owners transferred those rights to Holiday Oil. Does that make sense?
Mm-hmm.
Where were we? Level of service?
What does it mean?
Okay, so just to back up on your question of level of service, that's just kind of a rating, A to F, that's given. A meaning no congestion, F meaning congestion. That's kind of, and then there's a range in there, but it's not quite like your kids' grades. D is what we designed for. So typically, if you have a level service D or better, that's considered a good thing in terms of that, because again, we're looking at that peak time, that 5 to 6 p.m. or something like that. When we actually do the analysis, we even do things, and I'll try not to get too technical, of a peak hour factor. So really, all of our analysis is really measuring the worst 15 minutes of that 2-hour period. And from that, we're able to come up with an average delay. And this is through modeling and through, a fixed process that's defined by the Highway Capacity Manual. And all that letter grade is because people tend to like that better than seeing 34.7 seconds of average delay. But all it really is quantifying. And so one of the tables in our study identifies this range of delay means this letter grade type of thing. And so it's kind of defined, and it's slightly different for unsignalized intersections versus signalized intersections. And so just to give you so on this updated study that we did, we went out there, we used signal timing, the geometry, the new volumes for 2023. And overall, the intersection is functioning at a level surface B, which is great. And the unsignalized intersections, because we looked at apartment accesses, we looked at 3100 West and some other things in there, they're all in the BC range as well. So that's what's happening out there right now in terms of that. So we say, that's great. Everything's in good shape. That's where we want it to be type of thing. When we did our analysis for the intersection, we identified that that with the development that we were recommending a flashing yellow light be added to the signal so that they could have some protected phasing in there for some of the left turn movements. So that what the flashing yellow does, that's UDOT standard, is it also has a green arrow that can be activated if typically about 3 cars, that's usually the magic number, we assume 2 can make it through on the yellow. So about when 3-car position is activated, then it will trigger the need for some actual green arrow time so that the left turns can have some protected movement. And that was the mitigation that was recommended for the development. Just to give you an idea with this, and the other thing we do in traffic studies is we also project out 5 years into the future as well. So we use the historic background growth that's there. We up those numbers that we counted to be a background growth factor. And then we put our site traffic on top of that. And so in theory, we're saying it's not, here's how it's going to function when it opens, but here's how it's going to function in about 5 years based on our best estimates and engineering judgment. And in 2029, with the site and that background traffic growth, in the morning, we're still at a level service B. In the evening, we do move it up to a level service C. But both of those, with the recommended mitigation of the flashing yellow, brings it back down to a B for both AM and PM. So in that regard, they're mitigating with the recommended mitigation, they're offsetting their impacts. And that's the purpose of the traffic study, is really to identify, quantify those issues, and then come up with reasonable mitigation to offset their impacts so that the traveling public doesn't really see a difference. It's like they do enough improvements to offset their impacts, so it seems like it's pretty much the same as what they're seeing out there now.
So typically, when you give a study with those kinds of results to a city for a construction of anything that's near an intersection or similar highway, what kind of redlining do you get back when you have levels B and C on, and the number of seconds of delay, et cetera? Is there a lot of redlining that comes back from that? I mean, apparently the traffic engineer never saw it. So just assuming, what kind of response would you typically get back?
Typically, it's actually interesting. We don't usually get a whole lot, because the red lines that would come back would be if there was a problem with some of the fundamental assumptions. Like for some reason, because most of it's pretty laid out. The trip generation comes from the Institute of Transportation Engineers. So that's based on the land use and the size. There's no kind of fudging that or anything. It's defined, and everybody uses the same book, basically. The methodology comes from the highway capacity manual. Where we would get comments back would be something like, you put 40% of your traffic south, I think it's more like 50%. And so the origin destination of where that traffic is going and coming, sometimes, because it's subjective to my engineering judgment, and I base it on, well, what are the turning movements at the intersection and what data we've collected to come up with a reasonable estimate of that. But sometimes those little changes would come back and say, hey, could you assign more traffic this way or that way, type of thing, because that affects what is a left turn or a right turn, right? Depending on how it comes in or out of the site. So that could affect those movements at the intersection. That's typically the red lines that we get. Everything else is pretty straightforward. Or if we haven't scoped it appropriately, and people feel like, no, it's defined how far you go from your development typically in terms of what intersections you include. But sometimes there's little nuances that, your city transportation engineer would know and say, hey, could you also include that intersection as well? Or I'm worried about this one over here. And could you talk about that alignment with it, and how it lines up? Because those are where we start to get into troubles, when we start trying to misalign accesses.
So kind of tweaking kinds of questions, it sounds like.
They're always something that usually you can do in a day, respond back to. But typically the information is again, so the transportation engineer can review it. We do the work for them so they can review it and just basically say, yes, I agree with that, or I have a concern with this. Is that appropriate mitigation? And then they can make that a condition of approval, is, hey, you need to make sure that this happens. This is a UDOT signal. So the applicant will be dealing with UDOT for these improvements, not the city. But that would be the typical red lines we would see.
Well, thank you.
First of all, are there any other questions that anyone has before I?
Madam, may I ask one? So your letter's part of the record.
Yes.
And in your letter, it references an August 28th letter that you've mentioned about that went out to the neighborhood that contains that phrase, complete application. You also reference an August 30th written confirmation from the city, but there wasn't anything attached with the date of August 30th. I don't know if that was just a mistaken reference to the same August 28th letter, or did your client receive something on August 30th?
I believe that was an email that the client received stating that they'd received what they needed to receive.
That would be, it would be really
You have that
helpful to
right.
have, if that could be made part of the record, if that exists.
Unless that's regarding the site plans.
Yeah, I don't know. It's just in Mr. Mansfield's letter. He references an August 30th written confirmation received from the city, but there's nothing attached to his letter.
Let me look at my letter
Okay.
here a minute.
I'm sorry.
Sorry,
If you want to finish your presentation and look for that,
Yeah,
that's,
I have a copy of the letter, but there's no date on it. And I think that's the letter where they were incomplete application determination
No.
letter. Was that on the 30th?
Let me see what,
so in your, in the third paragraph of your letter, about halfway through that paragraph, it says on August 30th, Holiday received written confirmation from the city that the DRC packet submitted by Holiday was complete.
yes, I see that.
That would be awesome if we could, if there's a document that could be submitted to the record.
We will
Okay.
look for that.
Thank you.
So the issue here is whether the application was complete. And reference is made to Orem City Code 22-14-20 subsection E8A. And it has two requirements that city staff has said is the basis for finding that the application is complete. First, an analysis of the off-site traffic impacts resulting from the development of the site and a description of the mitigation measures necessary to reduce the identified impacts. Two, an analysis of internal traffic circulation patterns and their effect on ingress and egress from the site for emergency vehicles and the public. The traffic study submitted with the application, the 2020 traffic study done by Dr. Perrin and ATRANS, does meet those standards. It does include an analysis of the off-site traffic impacts resulting from the development of the site and a description of the mitigation measures necessary to reduce the identified impacts. Dr. Perrin discussed that. He discussed the flashing yellow light and other measures that were taken to address that. It also includes an analysis of internal traffic circulation patterns and their effect on ingress and egress. It meets the requirements of the Orem City Code. Now, they may want an updated analysis, but the process should have been to, if staff wanted an updated process, felt it was, or updated study and felt it was necessary, they should have requested that in the red lines, not subsequently deny it as being incomplete. So based on that, we think the city made an error in denying the application for incompleteness and the city council and then the application then being rejected. We think there are vested rights here based on this application. It was inappropriate for the city to deny the application based on incompleteness for the traffic study. But even irrespective of that, the development agreement gives them rights that now the city, yes, the city has a right to make a zoning change, which is what they're attempting to do at this point. But I think this was just an end run to satisfy neighbor concerns that this not be built. But it was an inappropriate effort to do that. We think this, we'd ask that the board overturn the city's determination and allow this application to go forward. Thank you.
Okay, will the city make their presentation, please?
Chairperson, board members. My name is Jake Summers. I'm the Deputy City Attorney for Orem City, and I'll be addressing the board tonight. Ultimately, this really does come down to whether or not the application submitted by Holiday Oil is complete. Utah Code 10-9A 509C governs whether or not an applicant's application is complete. A land use application is considered submitted and complete when the applicant provides the application in a form that complies with the requirements of the applicable ordinances and pays all applicable fees. The question here for the board to review is, was Holiday Oil's application submitted in compliance with our ordinances in a form that meets those requirements? The city's position is it did not. That it did not comply with our ordinance, did not provide the information in the form required by our ordinance to be considered a complete application. So site plan applications are governed by Orem City Code 22-1420. In particular, it lists out all of the documents that are going to be required for a site plan to be considered complete. It does so in 22-1420E. And it says, anyone requesting approval of a site plan shall first submit to the Department of Development Services all of the following. Included therein is a traffic study. That traffic study shall include all of the following. The traffic study has to include analysis of off-site traffic impacts resulting from the development of the site and a description of mitigation measures. It also has to have an analysis of internal traffic circulation patterns and the effect on the ability to access that site by the public and emergency vehicles. Respectfully, I disagree with Mr. Manfield's presentation tonight. That traffic study submitted did not meet these requirements. It didn't meet requirement 1 based on what we've already outlined in our legal memorandum, but 2, it wholly neglects to address the second requirement. I'll address that in more detail in a moment. So as to, did it provide a analysis of the impact, the off-site impact of the development by the development of the site? No, it didn't, because 1, the traffic study was prepared in March of 2020. Here we have an application being submitted in August of 2023, 3 years later. The traffic study was prepared during the COVID-19 pandemic, not just during the pandemic, but during the period of time that public places were closed, public businesses were closed, people were working remotely. The traffic study in particular, and I'm just gonna, I'll read from it because I think it is important to note, because I have to disagree with Dr. Perrin's analysis that the adjustments accounted for an accurate and reliable count, because the study itself submitted reads this: as a result of the change in traffic patterns due to COVID-19 pandemic, the data gathered, even with the multipliers applied, did not yield volumes that would be expected for these types of developments. Therefore, trip generation per ITE and distribution per the assumed origin destination was done for each of the surrounding parcels, and these values were used as the existing traffic. So even the data that they collected in March of 2020, even using UDOT's multipliers, did not account for the anticipated or typical traffic that would be located in this area. Why was a traffic study not completed in 2023 that was updated that would give accurate, current, reliable data for the current now existing conditions, rather than rely on a traffic study provided and collected during the COVID-19 pandemic? The traffic study was also prepared prior to changes to the roadway infrastructure. Again, Dr. Perrin acknowledges that this traffic study was done prior to the installation of a traffic signal
that controls the intersection of 2000 South and Geneva Road. The installation of that UDOT signal now changes even the variance that they're going to be able to obtain from UDOT. UDOT has specific regulations about spacing between an intersection that is signalized and access points, and what access points can be done. In the site plan provided, they're requesting a 3/4 access on the Geneva Road access point. Now with the signal, even the 2020 traffic study acknowledges that this is likely going to need to be a right in, a right out, which is not reflected on the site plan submitted in August of 2023. The submitted traffic study contained unreliable data and assumptions. I'm not going to belabor this point. As I already stated, rather than using the actual counts they collected in 2020, they tried to use the multipliers. And then when that didn't work, they went to ITE modeling to try to generate what this impact would be on the neighboring area. Then the submitted traffic study contained incorrect information. Specifically, what I would point to is in the 2020 traffic study on page 25 of their traffic study. In our packets, it would be page 152 and 153. There's a safety index score for how safe is the roadway. Now we'd be looking at Geneva Road in 2000 South, but rather than looking at Geneva Road in 2000 South, we've been given the safety index score of State Street. So as staff would look at this, we're looking at a safety index for a roadway that's not near the proposed site development. Further, on page 25, the same page, as it talks about what guidelines and requirements are needed for the access point on 2000 South, they refer to the Orem City access management standards. Orem City is not the roadway authority for 2000 South. Provo City is the roadway authority for 2000 South. So it would be Provo City's access management standards or guidelines that would govern the access point on 2000 South, specifically how it misaligns with the southern property on 2000 South, and what mitigation measures would Provo implement or want to be implemented by the development of this gas station on the 2000 South parcel. So again, staff is faced with incomplete or incorrect information in this traffic study. The second non-compliance issue is because the information, the data upon which the mitigation measures rely on, those measures are not accurate or not reliable now. So if we use incorrect modeling or incorrect measurements to say this is how we mitigate the traffic, well, can that mitigation actually be true mitigation? Now, again, I'm going to just, not to belabor the point again, but on Geneva Road, there's going to be a requirement for a variance because of the spacing for the access point on Geneva Road. It's within their spacing guidelines. The site plan still asks for a 3/4 access point. Likely they're going to need a right in, right out, but we don't have the information from UDOT as to what variance is going to be allowed for us to accurately measure and mitigate that impact. Same issue applies on 2000 South with the misalignment of the apartment complex that is on the southern side of 2000 South that would misalign with the 1981 gas station. The third issue is, and probably even the most problematic issue here, is while it has been represented tonight that this traffic study meets the requirements, it wholly fails to mention the internal traffic circulation patterns of how traffic is actually going to proceed on this parcel once the development is complete. We don't know how vehicles are going to be able to access, enter, circulate within the property. How is gas or diesel going to be delivered to this gas station? It's not lost on the city and city staff that this is a gas station that is going to be the delivery point and access point to combustible fuel and hazardous materials. And we have no analysis, no discussion regarding the access or the ability of emergency vehicles to respond to this site and handle any sort of emergency issue. You can search the entire traffic study. There is not a mention of a firefighter, fire engine, emergency vehicle, police vehicle, emergency services. Nothing of the type is found within the traffic study. That in and of itself constitutes that this traffic study does not meet in form the requirement that has been put in place by our city code. All of the required information has to be presented in the application for it to be considered complete. If it is not, staff cannot accurately review that land use application. There's been much said tonight about redlining. Redlining is a process done by city staff to try to bring an application into compliance or into conformity with our ordinance, to provide that information in a form that is compatible or in compliance. I'm just going to quote two opinions. The first is the advisory opinion number 40 of the Utah Property Ombudsman. In there it says, likewise.
Excuse me, can you explain what that is?
Yes, so individuals can appeal or seek a review of land use applications or denials, modifications to the Utah Office of the Property Ombudsman. And there an attorney reviews whatever the issue is, kind of acts as a mediator in some aspects, and then issues a ruling. It's an advisory ruling. It's not binding, but it is informative nonetheless.
What was the date on that?
The advisory opinion, I can pull that up here in just a moment. Let me exit out here. And I will. So 2008, April 29th, 2008. And in there, I'll just scroll down and I'll have it here so it's on the screen. So likewise, a municipality may take steps or allow the applicant to take steps, either through amendment of the application or modification of the zoning to bring the application into compliance with its ordinance. In such event, the applicant continues to rely on the validity of an unvested application at its own risk, as the municipality may be free to deny an unvested application at any time. However, no reason can be found to mandate a finding that an application cannot be pursued simply because it's not entitled to the approval on the day that it was submitted. So ultimately, during the period of redlining, this is really them relying on an unvested application while city staff works with them to bring that application into compliance and to provide that information in a form that meets our ordinance. Further, the Utah Supreme Court in Jack Schmerbel versus Salt Lake City Corporation. This is a 1988 Utah Supreme Court case. Its citation is 758 P. 2nd 897. In that case,
Can I ask a quick question?
yes,
Was either the ombudsman opinion or the Supreme Court case part of your legal memo that you submitted as part of the packet?
I did not include those opinions as part of my package.
Again, and we can consider those even if you submit them tonight, but it would be helpful to have a copy if you want the board to use those in its decision. So, thanks.
So there, the Utah Supreme Court says, allowing persons to obtain vested rights under a zoning ordinance merely by filing preliminary and incomplete papers would defeat the very purpose of zoning regulations. So again, when somebody provides deficient or insufficient or incongruent application, yes.
Read that again.
Yes, allowing persons to obtain vested rights under a zoning ordinance merely by filing preliminary and incomplete papers would defeat the very purpose of zoning regulations. So in this case, by knowing that the city council had a disfavor towards having this development go forward, because it was done openly and transparently at a public meeting, where the city council made a discussion saying, you know, we don't really want this development, so maybe we rezone it. And during that discussion was very much an open conversation about rezoning this parcel from a C2 to another use, a professional office use, or an R8 use, but to some other use. And after that, city staff filed an application to rezone that. It was only after the city filed its application to rezone that Holiday Oil then submitted their application, including this deficient traffic study. It was done in a way to try to beat the clock, to beat that pending legislation. So,
may I ask?
Yes.
It's probably, I haven't heard a discussion, and there really isn't one in the packet about what the pending legislation doctrine is, because in this case, dates are really important, especially September 6th. So it might be useful for both sides to maybe give the Board of Adjustment a bit of some context and explanation about what the pending legislation doctrine is and why the dates, especially September 6th, when the Planning Commission considered that zone change, why that date is so important.
So from the city, the pending legislation doctrine is once an item becomes pending legislation, any subsequent application is going to be subject to that pending legislation. So it doesn't get that grandfathered vested right of what the zoning rule was before.
Yeah, maybe be specific, right? So in this case, once the city decided to initiate a zone change on this property, right, then it is kind of is it considered before an application is made? And because that becomes very important as to whether the rights vest. So rather than speaking generally, it might be helpful to be very specific with these facts and these dates so that they have a clear understanding of the process.
Yeah. And so I'll give those dates. So on August 16th, 2023, the City of Orem's Development Services Department filed an application to amend the zone from C2 to a professional office zone, or PO zone. Now, the fact that we filed the application does not make it pending legislation at that point. It would not become pending legislation until it is actually heard by the Planning Commission or considered by the Planning Commission, which would be September 6th of 2023.
So the importance of that is if an application then comes in before September 6th and it's considered complete, then it's vested, even if the city council then changes the zoning after that. Again, that would only apply to projects going forward. It wouldn't apply to this applicant's project.
Was the application,
Yeah, I think
when did the application come in from Holiday Oil?
Yeah, I think he'll give you those dates.
Okay.
So on August, again, so to go back, on August 16th, 2023, we filed an application to change the zone from C2 to PO.
Mm-hmm.
Then on August 21st, 2023, Holiday Oil submitted their site plan application to the Development Services Department.
So that was after the,
It was after we had filed the application, but prior to the
this.
September 6th Planning Commission
Right.
meeting.
Right.
And then on September 20th, we issued the letter indicating that the application was incomplete. So I think those are, we issued a letter or statement to Holiday Oil that their application was incomplete.
And what was the date of that one?
And we did that on September 20th
Okay.
of 2023.
I would like to have clarified what the procedure is then with accepting an application complete. At what point does that happen? What's your procedure when somebody, not necessarily Holiday, but anybody goes through this process? How do you typically notify, even though they've turned it in and paid everything, but you haven't reviewed it yet? Where's the process of saying, yeah, we're going to move forward? Because they were saying, we did all that, and then we started receiving,
So, Member Crossen,
information.
I would answer your question. I think there are two different avenues that this can be done. First and foremost is during the technical review or the technical bringing something into compliance by staff, that is the form review. And it doesn't become complete until it goes to our Development Review Committee, DRC. And that's actually outlined in our code, that an application doesn't go to DRC until that application is complete.
So it hasn't ever gone to them?
It never went to DRC.
Oh, okay, that's a good clarification. Who did the redlining then?
So different city staff members within Development Services did. Those red lines did not come from DRC.
Okay, so this project had never gone, from my understanding under your ordinances, when an application comes in, the Department of Development Services reviews that, determines whether it's complete, I guess. This is 221420 subsection C. And then it says, shall forward a complete site plan request to the DRC members for review. So it's the city's position that this project, even though it was redlined, had never been to DRC.
That is correct.
What would the DRC review then have entailed if it had already been redlined by city staff?
So DRC then starts doing the substantive review. Does it meet our ordinances for use? And then once DRC has done that review, they would then vote, say, yes, this is complete. Yes, this meets our ordinances. Now it goes to Planning Commission.
So all of the red lines, and sorry, I'm just trying to follow a timeline here. I believe August 29th, the applicant receives red lines back from the city. That's the one that didn't mention the omission of a traffic study. So you're saying that all of those red lines, none of those had to do with bringing the project into conformance with city ordinances. All those red lines were related to whether the application was complete or incomplete.
Yes.
Okay.
And to continue, to come back to 221420 C1, to continue reading, it says the DRC shall forward a site plan to the final approving authority only if it complies with the general plan and all city ordinances, resolutions, and policies. So that's what the DRC redlining process is bringing that into compliance with ordinances, the general plan, et cetera.
So,
And you said that it never got to the DRC?
It never went to DRC.
so you're saying that your redlining that was sent to them was not an attempt to help them become compliant?
It was an attempt to help bring them into compliance.
But you weren't giving them a green light, like we're good to go.
No. So, so the application was incomplete, and just to finish off this, is really, it only becomes complete and then it goes to DRC for review. That never occurred here.
And that's the standard you always use on any development within the city. Nothing's approved till it goes to that committee.
So DRC, nothing goes to DRC until the application is complete.
Okay.
I'm sorry, so just to confirm, so this still has never been submitted to DRC?
Correct.
Okay.
And define DRC, please.
DRC is the Development Review Committee. It is a committee of different city staff members. I can't tell you who they are. I don't know all the different members, but they meet regularly. I want to say they meet bi-monthly or bi-weekly. It's weekly, okay. And they review any pending land use applications.
Can I just ask a question to clarify something? Everything that you have presented to us was based on the traffic study from 2020.
Correct.
It didn't have anything to do with what was submitted in October 2023.
Correct. We have not reviewed the applicant's submittal in October because it came after our decision that their application was incomplete.
Okay.
So just a couple follow-up questions would it be accurate to say that the city staff members that gave the red lines are members of DRC?
I don't know that I have knowledge to answer that question, sorry.
And I guess just to get a sense of how this process works. So when the geotechnical report was missing, how was the applicant notified of that?
I think one of our staff members would have reached out to Cheryl, requested that Cheryl say, hey, would you please submit this? This is missing.
Okay. And so, and the red lines, are the red lines delivered, were the red lines in this case delivered similarly through Cheryl, or would they have come through a different process?
Cheryl, can you speak to that?
The red lines would have been sent to the applicant via email.
From you or directly from the staff members reviewing their
There's two
their
of
areas
us.
of
There's myself and Michaela. We're kind of like project managers, so to speak. So we collect all the red lines from all the departments, public works, water, sewer, engineering, transportation, planning, put them all on a Word document and send that Word document with the actual plans that have been redlined to the applicant and the engineer via email.
Yeah, I'm just trying to get a sense of, I know sometimes in ordinances, it's very clear, but sometimes a city's practice, it can be a little bit harder to categorize, where one starts, one stops. And so I'm just trying to get a sense of how the process works in Orem City, and especially to help the board understand that.
Mr. Crosshat has a question.
So just clarify in my own mind, and I don't even know if this information's accurate, but it seems to me that like when Alpine closed schools and the property was there, the city went and changed the zoning so that schools had to be built, or that property had to be used for school facilities, or like the park, that kind of, it changed the zoning so it couldn't be developed with housing or commercial. And so what you're saying is you're going to change the zoning for that use again.
Board Member Cross, I believe you're referencing our public facility zone that was enacted. Yes. So during that period of time, when the city became aware that some schools may be closing, the city enacted a public facility zone, which changed the potential use for the properties where city parcels or parcels that had been paid by Orem taxpayers, they would be basically kept in a way that they would be used for government, schools, parks, open spaces, public use, based on their unique and nature of being bought by taxpayer dollars.
And so you'll be changing the zoning from a C2 to another use. So if they don't get approval here, that property won't have the C2 in the future.
Pending legislation, yes, Member Cross, it is. The pending legislation is that the property located generally at 1981 South Geneva Road would be moved from the C2 zone to a professional office zone. So it changes the use, the ability to use that property. It doesn't prohibit further development. It just changes what future development could be there.
Okay. And I guess I'm not taking sides. I'm just trying to look at the whole picture. So at that point, and I guess that's why they're talking about being vested. They've invested money into the project, but because they didn't submit a complete application, the city declined.
So, yeah,
And so it's really, you're saying that's on them and.
correct. That we weren't engaged in any sort of malicious behavior. Their submittal, their application was done incompletely. Had it been a complete application, they could potentially be vested and be able to move forward with the development as outlined in their site plan application. But where that application was not complete, they don't get the vested right. And then the pending legislation is going to ultimately change the use of this parcel.
Okay, thank you.
Madam Chair, I have a question.
Yes.
So about nearly 4 years ago, 3 years ago, when this was purchased by, or when the agreement was made with the city, the development agreement, I mean, a lot of time has passed since that happened, and suddenly we're having a race. Why?
So my opinion is, ultimately, the developer, Holiday Oil, had the ability to develop the land under the C2 zone and the development agreement if they had submitted a complete application.
Yeah, but why are we racing? That's my question.
Ultimately, as they stepped in and then were assigned the development agreement, Holiday Oil decided that the original development agreement didn't meet what they wanted to use on that parcel of land. They sought to modify the development agreement and expand what they could do under that development agreement. Once they did that, there were several public hearings, both at the Planning Commission and at the City Council. Public came out, educated the City Council on problems that they spotted in this development and issues that they saw that would change the character of their neighborhood. And as they did that, the elected officials had an open and transparent conversation at a City Council meeting saying, you know what, it may not have been the wisest decision in 2020 to rezone this land to a C2 use from the open space 5 zone. And perhaps we should rezone it to some other use that fits better within the neighborhood. That conversation then led to city staff filing an application to rezone it from a C2 zone to a different use. Then the race began. Can we get an application in before that pending legislation? Can we get the application in before the September 6th date when this is going to go before the Planning Commission? That's the race.
Thank you.
This is hard for everybody who's participating. And we're definitely, I'm a resident of Orem. And I've been here for 30 years and, I'm an executive for the Kingarth Automotive Group. So I've been in business here for a lot of years here in Orem. So I just, it's hard to make a decision. You're never going to make everybody happy. And I understand how some of these questions are being answered. Sometimes it feels like, we got to say the right words. I'm just going to say simplified my analysis. If I can do that, just kind of understand 2020, the city came to an agreement that, hey, let's change this to C2 for whatever information we had. And then in 2022, it was sold to the Holiday Group. Is that right? Okay. And at that time, I don't know how much conversation was there about this development from 20 to 22, but from 20 to 22, I'm assuming no conversations between Holiday Oil and city happened until June 21st of 2023. Am I to believe that?
So I don't know that I can represent anything about conversations that occurred.
No, the question of that is, I asked that question because did the city know, did staff know that these Holiday Oil people were still pursuing, to develop this, gas station? If they had, why wasn't there any conversation about, hey, we ultimately want to change this? Well, part of that's they don't want to show their hand, because the city has a master plan, and I'm for these master plans as a citizen, but at the same time, in good faith, it seems like, and I'm just making it an observation. Again, there's 400 and some pages here. It seems like to me that there was more conversations, and at one point, there had to been an opportunity for the city to say, or start not even redlining, just, sending back, hey, the city's changed, it's going to be changing. The master plan doesn't show this. In 2020, I'm assuming that the residents that are right behind it weren't there.
So I believe you're correct, Board Member Iglesias, is that in 2020, much of what is now there was not there. Homes were under construction, but may not have been occupied. There were still open parcels in that residential neighborhood that backs to this development. Also, there is a development to the west that hadn't been completed as far as a build out. So again, many of the residents, many of the public who came out to these public hearings weren't there in 2020. And so again, because we have this change, this delay in time, we also have a change in character of the neighborhood. We have,
For sure.
We have neighbors who are now there, living there and saying, wait, hold on, this was zoned for a gas station? I didn't know this. And based on that, that educated both the Planning Commission as well as City Council as to potential issues with this development.
And those meetings were held, public hearings were held when?
Those public hearings were held in conjunction with the application by Holiday Oil to amend or modify the development agreement.
And that was
That would have
September
been
6th or August?
Of this year.
Okay, so I think now I understand this rushing that you're saying, that the race to this, these public hearings. So this never became a concern until August of this, because citizens finally got their information. Did they never know, did they never understand or knew what that corner piece was set aside for?
So Board Member Iglesias, what I would say is on March 1st of 2023, Holiday Oil filed an application to request the Planning Commission to amend the development agreement.
And this is in March.
March of 2023. And then the Planning Commission held a public hearing on June 21st of 2023. So the Planning Commission holds their public hearing on June 21, 2023. And at that point, neighbors are notified by law, hey, this is going before the Planning Commission, and there's a public hearing. Then in August 1st of 2023, the City Council hears the same request to modify the development agreement, and there's a public hearing. So those are the dates.
And I think you, in your legal memo, I believe it's the city's representation and acknowledgement that part of the discussion about the amendment was, after they, either during or after they declined, was basically, hey, we ought to look at changing the zoning. And I don't know if part of the motion was an official direction to staff to start the process. We don't have the motion for that in the record, but I'm assuming it was something like, and again, it was very public that City Council said, hey, we might want to take a look at changing the zoning.
Yes.
It wasn't a secret. It wasn't again, lots of residents don't necessarily pay attention to every City Council meeting, but those that were there, and certainly the applicant would have known at that August 1st meeting what the city's intention was. Whether it ultimately was approved or not was still, wouldn't have been determined, but the city council made it clear that that was the direction that it wanted to move in.
Correct.
Yeah.
And based off that direction, city staff then filed the application. It wasn't so much city staff knowing that we were going to change the zone at some point back in 21 or 2022 or even 2023. It wasn't until the public hearings and the conversations in those public hearings that city staff said, okay, we will file the application to rezone this parcel from a C2 to another use.
Okay, so in my understanding and making it fair for everybody, it's in good faith, the city, was supportive of Holiday Oil in its current code. And then as things changed or we had public hearings, then hey, we got a kind of an understanding. At the same time, Holiday Oil in good faith in their communications from 2022 also assumed that the city was okay with conversations, because nobody is saying that there was, but I'm assuming there's conversations that happened between that period, between 2022 and June or March. Yeah. So we're going down to a technicality. If it's submitted, was it submitted correctly? There's a letter or in one of these pages or somebody mentioned that it was a complete, it's the mayor and the city council said it was a complete application. If they spoke in that terms, and did they speak it in their current offices? Maybe they misspoke, but were they speaking in behalf of themselves, or does this not exist? But I'm assuming they spoke as a city mayor and a council, confirming that this is a complete application. But there is a way to do this, right? There's a technicality how to do this, and you just identified that they didn't do it.
So I'm
just trying to understand. I'm just trying to understand.
Board Member Iglesias, I don't mean to quibble, but I don't think it's a technicality. I think it's a substantive issue here where their application was deficient. And it was deficient because they didn't provide the correct document. And because they didn't provide the document with the required information, we can't deem it complete. I don't think that's a technicality. I think that's pretty substantive.
Can I ask a question, Madam Chair? Yeah. Because that's part of the record, and it's been brought up both by the applicant and now by a board member. Could you give us the explanation of where that letter came from, who drafted it, upon whose advice? Because it's an official communication it's on Orem City letterhead. It says it's not signed, but it says City of Orem Mayor and City Council, and especially because it uses the important legal phrase, right, that the board's going to have to grapple with, completed application. Can you kind of explain to us what was the generation? On what basis was that letter generated, and why, on whose advice did it say completed application?
So that letter was generated as a public service information to the neighbors. And because the public hearings were so well attended, frankly, and because there was so much concern in the neighborhood, once the application was given and received by the city, then city management believed that it was appropriate to let the neighborhood know, hey, an application has been provided to the city that's going to basically allow this thing to process and go through the system. The use and the phrase complete application was not meant to be a legal binding message. There's a specific statute to allow this to happen. That was not implemented here. So Utah Code 10A, 9A, 509.5 actually talks through this process. This process was implemented in 2007 when that code was written into law. And a developer, after a reasonable period of time of having submitted their application, can submit a written request saying, hey, I gave you my application. Can you tell me what the status is? Is it complete or is it deficient? And the city has 30 days to respond in writing. And if they fail to do so, then their application is deemed complete. So once the developer writes that letter, says, can you tell me what the status of my application is? the clock's on for the city to respond in writing. That never occurred here either. The developer never requested a status of, is my application complete or not? So this letter that was issued by city management is not a binding legal statement of completeness. Further, I think some of the concern from the board is, would the developer have relied upon that statement to its detriment? And again, nothing really occurred after that letter until we had sent our letter of incompleteness. When we stated, look, you missed the requirements to submit a complete and effective traffic study under our ordinance. So there was no reliance on that letter.
Is there a document that, because I didn't see it in our papers, the city's response that it is incomplete?
Yes. So in my legal memorandum, I attached several exhibits.
Oh,
and
yes.
Exhibit 8 is the letter that was sent indicating that their application was
Okay.
incomplete.
Thank you.
Madam Chair, I have a question.
Yes. Oh, thank you.
Just one other clarification. I think Holiday made the representation about that second study that you didn't ask for the study, and that was, they're representing that was on the city that you should have. And I'm assuming that that isn't on the city from your perspective, that was
Correct.
on them to submit that information. Because I think it was mentioned that a study should be updated every 18 months automatically to have accurate information. And so they didn't submit something after the 2020 to update that. And
So,
that
Board Member Crossett, no, we did not ask for the 2023 traffic study that was submitted in October. We did not ask for that. That was provided to the city after we had told Holiday Oil or informed Holiday Oil that their application was incomplete.
and that wasn't your responsibility to do so.
Correct.
As part of the application.
That is correct. In Holiday Oil's legal counsel's letter indicates the city engaged in malicious behavior, abuse of the police power, and then politicization of the planning process. And really, ultimately, everything the city did was open and transparent throughout this process. And again, I'm going to fly through these dates. If there are any questions, stop me. But I think we've already discussed a lot of this. In 2020, the city of Orem rezoned that site from OS5 to C2. At the same time, the city concurrently executed a development agreement, which specifically limited the land use availability on that site. The development agreement did not grant any sort of vested right. The development agreement didn't extend any rights or any additional abilities to do anything other than limit what they could do within the C2 zone. Specifically, the development agreement also contained a provision that said there's no guarantee that the city council will rezone this to a C2 zone.
Actually, it didn't say rezone this, it said rezone. It didn't say rezone this. It could have been rezoning the surrounding areas. It really was not very specific.
But again, within the context of the agreement, it says the city makes no representation that the request of developer to have the property rezoned. So again, in context, 1981 South Geneva Road. So that would be the context of that provision is the city is not making any representation to the developer that we're going to rezone this property to a C2 zone.
Can I give a little explanation of that? So it's very typical for a development agreement to come through simultaneously with a zone change. And cities are very careful, right? So, because you don't want to promise something in a development agreement. Well, you can't bind a legislative decision in an agreement. So the city council can't can't say, in this agreement, we're going to agree to vote this way. So a development agreement always says, in maybe different words, but the effect is, this agreement only becomes effective if the city council approves the zone change, which is an independent legislative decision that we're not binding ourselves to by entering into this development agreement. So that's why you see that kind of language that says, hey, we're willing to approve this agreement, but it won't come into effect unless the city council then approves the zone change. So therefore, if they end up not approving the zone change, the development agreement just dies. It's of no effect. It's void. So that's why you see that language in a development agreement.
So as we've discussed this, and you represent us so that we understand the legal terms, is our decision coming down to the dates of this, regardless of everything else that's been said? Are we just looking at a date? Was it accepted or was it not accepted? And
the dates are only important because of the consequences. The only decision that you're making is on August 21st. Well, I guess, was the traffic study that was submitted, was it sufficient to make the application complete and therefore vested? Or was the application deficient because of the quality, for lack of a better word, traffic study that was made part of the packet? And so therefore it wasn't complete. And then because of September 6th, the Planning Commission, now we've started the process of rezoning. So even if they fix it after September 6th, it doesn't matter. They've missed their opportunity. Does that make sense? So you're not really determining a date. It's that your decision of whether a complete application was submitted prior to September 6th means either the developer is vested or they're not vested. That's the importance of your decision.
Are we considering the second traffic study in our decision then?
No.
If that, just the first one?
Yes, because the second one was submitted after September 6th.
All right.
And again, the applicant didn't, well, I'm going to ask a couple of questions to bring that out. But
Well, and if I could, the second traffic study came in after September 20th, after we denied or made the decision that it was incomplete.
Should I ask those questions now, or would you like Mr. Summers to finish his presentation? I can do either one. I don't want to keep interrupting you, so if you want to finish, I'll let you finish.
And then provision 8, the next provision in the development agreement, also specifically warned at that time, the parties to the development agreement, and then anybody else who took assignment of the agreement, that the city could exercise its police powers, meaning it could rezone the property in the future. It can enact a new zoning restriction, a new land use regulation in the future on this parcel. Holiday Oil at some point takes assignment of the agreement, but up until this point, no development had occurred. No site plan application had been submitted. Holiday Oil files an application in 2023 to modify that agreement. And then again, as we've already stated, there.
And that modification was for the car wash.
That's right.
Okay.
And I think there were some other modifications they were seeking, not just a car wash, but there were other modifications of the agreement. During the process of that, public hearings are held. There are very open public comments, conversations, discussions by the land use authority about whether or not to rezone the property. Staff files the application to rezone the property on August 16th of 2023, schedules a public hearing and consideration of the issue on September 6th, and provides notice to Holiday Oil. Holiday Oil then files its incomplete site plan application on August 21st. So their submission of a deficient application doesn't result in us engaging in malicious behavior. The city did not abuse its police power when we just acted according to Utah law and the development agreement, which specifically warned Holiday Oil of the city's authority to exercise this future police power and potentially rezone the property in the future. The arguments regarding, the Holiday Oil relied upon this development agreement and the C2 zone. Those reliance arguments are really ultimately unreasonable, unreasonable here because one, specifically, the development agreement provided no grant of vested land use rights. Secondly, we specifically warned that nothing shall limit the future ability to rezone the property. And until that application is submitted and it's a complete application, there is no vesting of rights. The city can exercise its police power and rezone. I've already addressed the issue of the letter that was issued in August 28th. Again, there was no request under 10-9A 509.5 requesting a status of completeness. This letter does not meet that requirement. It is not a binding statement of completeness upon the city. Also, there's been a representation. Mr. Wood had already asked Holiday Oil of this. There is a representation that on August 30th, they'd received written confirmation. We are not aware of any written confirmation of completeness. We have not seen any proof to support that assertion that any email was sent saying their application was complete. Ultimately, we are going to ask this board to affirm and uphold city staff's decision that this application was incomplete.
Madam Chairman, can I ask a question?
Please let her, let her go first.
So it seems like Cheryl was the point person. Do you know of anybody who sent the August email? Was it you? Do you know of anybody in your office who may have sent that email and what it said?
It was not me. It may have been Michaela. That I'm not sure.
So you aren't aware of anything regarding that?
I looked in my emails and I didn't find one, but I'm not the only person. So
Yeah.
it's
Okay.
still very
I just thought
possible.
that could quickly clarify. Thank you. Have you, with Holiday, found in your correspondence here that email?
The August 30th email?
Uh-huh.
I believe the August 30th, that was a reference to that is the date we received the August 28th letter.
Oh.
I assume that might be the case because nothing was attached that had a date of August. Thanks for that clarification. Okay. So you mentioned the process in Utah code where a developer can make a request as to whether the city has deemed the application complete. Are you aware of how often those are made by developers, if ever, to Orem City?
I cannot speak to that. I do not know how often that is made.
Are you aware of any ever having been made?
Yes, I am.
Okay. So again, with dates being so important, and it looks like from the perspective of both parties that there was a review process going on, right? Application submitted August 21st. Staff begins to review it on the August 24th. This letter goes out on the 28th. On the 29th, the applicant receives red lines. You've clarified that wasn't red lines from DRC, it was individual staff members. I think the board will want to have an explanation as to why it took till September 20th to tell the applicant that they needed to file that the city deemed the application incomplete because of the deficiencies in the traffic study. With September 6th being so important, I think the board needs to understand why it took the city until September 20th.
So staff continue to work and review the application. I mean, our decision that the mailing and preparation of the letter to indicate that the application was incomplete was done on September 20th. That was within 30 days of them submitting an application altogether. Again, if we were to look at 10-9A 509.5, it says a developer may request a status of completeness within a reasonable time. And then also, once that request is made, that it's done within 30 days. This decision was made within 30 days of them even applying or submitting that application to the city.
Yeah, and that's a good explanation, except the context here, right? I don't know how many staff members were reviewing this, but enough that, and again, I don't know the number of red lines that went back on the 29th. It seems like everybody else had done what they were supposed to do before it goes to the DRC. Why did it take till the 20th? And again, the important date is, why did it take till after the 6th? Everything else comes back to the applicant on the 29th. This is the only item that goes past September 6th. Was there something about the city's internal processes that caused that delay?
Yeah, there was internal conversations between city staff and the legal department about whether or not this was a complete application based on the traffic study.
Okay.
Ultimately, Mr. Wood, my position is, because the city engages in redlining doesn't tie us to actually providing red lines to everything.
No, you're right. Yeah, no, and again, I think the board is going, and I'll let them speak for themselves after my questions are done, but I'll be frank, it doesn't look good for the city to have given the applicant a list of red lines that had been reviewed by other city departments, and the one that then you based the incomplete application on. In other words, they had notice of everything else, right? And taking this all together, it seems like the applicant had no indication until after September 6th. And that's the important date. No indication, right? It's getting, in fact, everything weighs in favor of they were relying on the fact that it was complete. They get other red lines, a letter goes out on the 28th, no indication that there's anything wrong with the application until it's too late for them to do anything about it. And that's what I think we need to understand why that happened.
Other than staff took time to review the application in its entirety, to review the traffic study, review the other components. When there became a question about whether or not the traffic study met the guidelines, there were internal conversations, and ultimately we deemed the traffic study to be wholly incomplete and not sufficient for redlining.
Okay. Thank you.
No, I was just gonna ask Holiday Oil.
Okay. Thank you. No, I do not.
Thank you very much.
Thank you.
Let me go in a minute to the timing of what's happening here. Is everyone's acknowledged timing is important here. These dates are critical. The application was submitted by Holiday Oil on August 21st, 2023. That same day, Holiday Oil receives an email from Cheryl Vargas. First, there's an email from Cody Potter, to both Cheryl Vargas and Taggart, Jason Bench and Taggart Bowen, all at Orem City. It says, Jason and Cheryl, there are two things missing in the submittal from our side of things, and this is referring to the Holiday Oil application. One, geotechnical report. Two, percolation test and test hole bore where the storm tech system will be installed, showing the elevation of the groundwater and the infiltration rate of the soil from the percolation test. Thanks, Cody. That was sent to Ms. Vargas. Ms. Vargas then, about 20 minutes later, forwards the email to Brent Neal at Holiday Oil, also Michaela Wagstaff at Orem City, who's in the planning department, says, hi, engineering has found that the geotech report and perk test are not included with the application. We will need those before we can take this to the technical review committee meeting this week. We have another meeting this afternoon and may find more items missing, but I thought I would let you know what we have so far. Never did Orem City come back to Holiday and say additional items are missing. Now, the law says that the inclusion of certain items and the exclusion is deemed to mean that not other items, in essence, are missing. And I think that's the law that would apply here. Now, we also have the letter from the Orem mayor and city council dated August 28th. These are exact terms. These are technical terms saying the application is complete. That is an admission of Orem City. And in a court of law, a court would find that that is binding upon Orem City. That is an admission of Orem City. Now, they also say this never went to the Development Review Committee. Let me show you the actual red lines. I just messed them around that we received. And this is a memorandum dated August 24th. Ms. Vargas did not send it to Holiday Oil. Michaela did with the planning department. The very top, it says City of Orem, DRC. This comes from the DRC committee, not just staff members. This is the DRC committee that provided these red lines.
Okay.
What date was that?
August 24th, 2023. These are the red lines we've been talking about.
I asked him to look at it because
Yeah, are these in the record?
we didn't know, we wouldn't know if that's a legit.
Yeah.
It would be hard to have it go up before DRC the date it was submitted.
Well, I'll take it now.
Okay, let me, I'll give it back to you.
Yeah, you need to.
I mean,
Let's just make sure it gets into the record.
yeah. But at the top, it says City of Orem, DRC. Nothing was mentioned about an incomplete or a qualitatively poor traffic study. That was not, nothing was mentioned here. There's 13 red line items on general, 3 on sewer, 26 on water, 16 on stormwater, 1 on transportation. The one, and that's where the traffic study would fall under. The one comment is submit the TIS, that's a traffic impact study, submit the TIS to UDOT for review and approval. HO has submitted, HO Holiday Oil has submitted TIS to UDOT with application. That was received. Let me see, where's my. That was received by Holiday Oil on August 24th of 23, or excuse me, August 29th of 23. This was received by Holiday Oil from Orem City. On 8/30 is when the letter went out from the mayor and the city council. On 9/5, September 5, so the day before the planning commission had its meeting to consider the zoning change application, submitted its responses to these red lines. So one day before, those were submitted to Orem City. Nowhere here do we have the Orem City engineer who would be responsible for reviewing the traffic impact study saying it didn't meet the requirements of the Orem City Code. All we have is argument from council. We have legal argument. Under the Orem City Code, there's 2 requirements. And what we heard from council was the imposition of requirements on the traffic impact study that are not within the Orem City Code. 2 requirements: an analysis of the off-site traffic impacts resulting from the development of the site and a description of the mitigation measures necessary to reduce the identified impacts. And 2, an analysis of internal traffic circulation patterns and their effect on ingress and egress from the site for emergency vehicles and the public. Dr. Perrin can address that. Those are in the 2020 report. Both items are met. According to this, the only 2 requirements in the Orem City Code have been complied with. Now, there may need, or Orem City may come back and say, and just because red lines come back does not mean it's not a complete application. A complete application means have all the items been submitted that were required to be submitted. The only one they're saying was not submitted was the traffic impact study. That was submitted. There's no dispute that the 2020 traffic impact study was submitted with the application. Question is, does it meet the requirements of the code, is what they're saying. And Dr. Perrin, you can ask him whatever questions you would like, and he can show you specifically in the 2020 traffic study where it meets those requirements. This was done. And if that was done, then it is a complete application and it is vested. And irrespective of whether they're moving forward, Orem City is moving forward with the zone change, that process started, as far as the timeline that's important, is September 6th. So as long as we got that in, a completed application before September 6th, this is vested. We have Orem City sending emails saying only 2 things are missing, and you have the Orem City Council and Mayor using the term complete application. Those are terms of art. That has meaning. It wasn't an accidental usage. This was a complete application as admitted by the mayor and the city council. Why it waited until September 20th to come up with the ruse that this was not a valid traffic impact study? As we heard, there's discussion between staff and legal counsel. They're coming up with arguments as to why and how they can reject this application so they can appease citizens who have objected. That is what's inappropriate here. That this has been shoehorned in to try and come up with a reason, to fabricate a reason as to why this is not a complete application. Yet you have acknowledgement from the city that this is a complete application. Based on that, we think we do have vested rights. We do think the actions of the staff should be overturned by this board. This board has the authority to do that, and we hope it does do that. I'd be happy to answer any more questions, and Dr. Perrin certainly can point to his areas of the report where it does meet those requirements. And we have no engineer from the city saying it doesn't meet those requirements. All we have is arguments from council. We have the actual engineer, a professional engineer, PhD, who says it meets that.
Can I ask a question? Patiently. Has Holiday Oil, because I thought I heard, has Holiday Oil ever put a gas station in Orem?
Yes.
Have you submitted a traffic or an traffic impact
study?
Have you done that before? Was it the doctor that did it?
Yes.
Okay.
No, I don't know if Dr. Perrin did not do it.
Okay. When that traffic impact study came back, was that any different than you're dealing with today?
I'm not sure what you're asking.
I guess, has it ever come to this?
No.
Have you ever been denied because of a technicality, because something wasn't put in?
No.
When in essence it supposedly was? And going back, let me just change this a little bit. If we go back to 2020, we're saying, and I think we agree as a citizen, things did change, right? From 2020 to today, right? But these 2 things right here that are in the announcement that council just read, an analysis of off-site traffic impacts resulting from the development of the site and description of the mitigation measures necessary to reduce the identified impacts. And number 2, the analysis of the internal traffic circulation patterns and their effects on ingress and egress from the site of emergency vehicles. Is that common to get that back as a red line? Or is there usually more or less?
Yeah, let me answer that and see if I get your answer. So this was from January 7th in 2021 when we developed the site over on 1500 West. And here's the transportation section. There were 14 red line comments, and not all of those had to deal with the traffic impact study. One of the comments here, need to include the AM peak analysis. See TIS page 2. Item number 2, TIS needs to discuss and verify that project access locations meet Orem City Access Management Standards, TIS page 2. There's a couple, well, actually, there's the bulk of them relate back to the transportation study. There's a few others that have to deal with the site plan with some site triangles and things like that. But that's what we would have expected to see when it came back on that initial review from the DRC.
Okay.
Did that answer your question?
Yeah,
And,
so
and
it's.
then I guess I'd also say I've never had an application in over 25 years of submitting through cities that was denied for, what do we call it, substantive reasoning. We've always gotten red lines. We've resubmitted. We kind of got into this race because the city was going to rezone the property out from underneath us.
Okay.
There's also a question about the June 22 timeframe. So Holiday Oil closed on this property and acquired it in August of 22.
Right.
In June of 22, Mr. Neal of Holiday Oil had meetings with Orem City, Jason in the planning department, about the development agreement. They're doing their due diligence to determine whether this was still a valid agreement, what position Orem was taking. And was told, no, this can be done. This is still valid. You can move forward. They actually acquired the property in August of 22, started their development plans and doing their engineering and so forth, submitted it. There was a neighborhood, is required by Orem City. There was a neighborhood meeting on February 7th of 2023. That's when the neighbors first, in essence, got wind that this may be happening. And then the application process went forward. There were public meetings as discussed in August of 23 regarding the possibility, the question of whether a car wash could be added.
Our first DRC comments as we were working with staff to see if we could get the car wash and then the reconfigurations. We wanted to change the style of building as well. Our first DRC comments from that were in March. So the first of the year we had worked on that, and we ended up going through 3 or 4 iterations of comments before we got to that August date when we had the meeting.
One more question on that document that that said that represented the DRC. Can we have that now?
Yes, we will.
This is not based on, we're going to make a decision just based on that. We just got to get all the information and what is.
Go ahead and make a copy and give.
And what's really important, is there anybody?
Give a copy to the city and one to me. Is that your, yeah, I mean,
Yeah.
I'm assuming we can go have a copy made of that.
Is
right now.
there anybody here right now at staff that can validate that actually is real? I'm not saying that I'm just saying, can anybody validate? You can, okay.
This document is actually the one that I resubmitted to the city, so it has my responses. When you do red lines, you add what your response is so that when staff looks at it, they can see where you've made changes.
Okay, go ahead, Ryan.
Ryan Clark, Development Services Director. So to give a little bit of background on our DRC process and to help clarify things, when I took this job about 5 years ago, we realized and came to learn that our city code was not being followed with our development review process. Our city code specifically identifies who is to attend that development review committee meeting: a representative from fire, police, public works, development services, and those people are appointed by our city manager to be on that committee. That has caused a little bit of confusion as to what the real DRC is. At that time, what we did, which was a process that had been followed the entire time I've worked at Orem. I've been here 25 years, but for 20 years, we were doing a process that was not, as far as I know, following our code. When that was realized, we moved to the new plan. So a lot of that nomenclature has continued to exist on top of our documents that are these checklists that are sent out. So it's kind of I don't know the terminology to it. It's part of the process, but it doesn't necessarily represent that DRC committee final decision. So what happens is when a plan comes in, it's sent out to the team that reviews it. We call that technical DRC or technical development review committee. That is when all of Public Works and everyone else looks at it. It then comes back and it goes to what we call project coordination. That's a meeting that's held separately after the technical development review committee. That's made up of planning staff, legal staff, myself, our planning manager and assistant development services director. we call it project coordination. That's when we finalize the red lines and the red lines go out on the document that was sent out. That document still contains the title Development Review Committee on top of that. However, that project does not move forward to the Development Review Committee that is in our ordinance until it is cleared by that project coordination group. So while that document says Development Review Committee on top of it, it's not a formal, it's just the name that's carried over. It's not final until it goes to that Development Review Committee. That formal committee has an agenda posted. It's a public meeting that's held every Monday if we have items on the agenda. And in that meeting, those members vote that this project is cleared to now move forward to Planning Commission. So I hope that clarifies the process a little bit.
Planning Commission? So the project review committee makes a determination. So when does it, maybe I just missed it.
The project coordination group that meets then sends out the red lines, or we clear it to move forward to the official Development Review Committee meeting.
Okay, yeah, you said Planning Commission, so.
Then that Development Review Committee meeting votes. We have minutes, we have an agenda, and that vote then determines if it moves forward to Planning Commission. So we have a multi-step process.
So this document that they're making copies of is the unofficial.
It's just the red lines
recommendations
of
before the red lines.
of everything leading up until a determination to take it to the Development Review Committee for final vote.
So where did you get this document?
This was emailed to us from Michaela.
Yeah, so it does, and I will acknowledge it says that on the top of it. It says that on the top of every set of red lines that we send out to for every single project. That is nomenclature that's carried over since this process. We've been doing this.
So how would a developer know that it didn't really mean DRC? How would they know that?
That's a good question. We do let them know that it does go to the Development Review Committee when that is put on the agenda, and they're notified that that moves forward to that point.
And then board member, I would also add, again, as Mr. Clark has indicated, the DRC is a public meeting that is noticed up. There's an agenda, there are minutes. So there would be a public meeting where this would actually have been discussed at DRC.
Well, since the people at Holiday Oil don't work at Orem City, how would they know that? I mean, when they get something that says DRC, why would they think that didn't really mean DRC? I just wonder if the city has some liability here by labeling something incorrectly that an entity would rely on, particularly after having had conversations with with whatever department in the city that they were communicating with. How would they know not to rely on what the city's communication with them really was?
Again, board member, I think we have to take this document in context with the email that it was provided. I believe the email that, again, I don't have the email in front of me, so I'm just going off my recollection. I think you received, or Holiday Oil received the email on August 29th from Michaela. And it was said, you know, the technical review committee has reviewed this.
No.
Is that not what you?
That's not the email I read. This was the email dated August 21st from Cheryl Vargas forwarding an email from Cody Potter of the same day. Michaela is the one who emailed that document to us, but I don't have that email in front of me.
Again, I'm struggling to understand an email that predates your submission of a site plan.
This was post submission. This was saying these two items were missing from your application. Please submit them. We did. We submitted it in the morning, midday at 12:37 p.m. is when Cody Potter sent the email to Cheryl Vargas. Cheryl Vargas then forwarded the email to us at 12:59 p.m., 22 minutes later.
That's all on the 21st, right?
That's all on the
That's
21st.
the date the application was submitted.
We submitted the application, then we got this email.
If you want that to be part of the
Yes.
record, could we get copies of that as well?
Okay.
So Ryan, so again, we can argue about what not argue, but we can try to figure out what the applicant knew or didn't know and should have, or, you know, but from the city's position, this document is generated by the technical DRC.
The technical and the project coordination.
And
group.
project coordination, okay.
One of the, and I don't know how to, maybe challenges we have is the whole entire process from application submittal until completion is always called the DRC process. It's called that in many other cities. So it's kind of generic nomenclature for the process.
And I guess, and maybe this is for your attorney to answer, but do you consider then until this, every red line on this document is checked off, that it's not a completed application?
Typically, in our minds, once it goes to the development review committee and it is voted on to move forward to planning commission, that is when it is affirmed in our minds that it's a complete application.
Once it's voted on by the DRC?
Well, that's when we know for sure it is a complete application without a doubt. As you may know, determining anytime a project comes in, it's a process. It's a lot of work. It's a lot of decision making, and it's a lot of trying to determine, you know, there's things that you don't necessarily see when the application comes in with red lines.
Yeah.
Initially, that you may determine later there's something missing.
Yeah.
There's a lot of things that can be missed.
Because I guess my understanding from what Mr. Summers said earlier is that there's kind of two categories of red line, or the review is kind of two pieces to it. One is things that are missing that make it incomplete, and then other red lines that are conforming it to Orem city ordinances. Is it your position that if some of these have the latter on them, that they're considered incomplete, even though many of these red lines are an attempt to just conform items with Orem city ordinances?
I don't know how to answer that, or if I can answer that, but what I can say is in the past on certain applications, we've had developers submit things just to beat deadlines that do not meet the intent of the ordinance.
Yeah.
And what's being asked to submit.
And I understand, right? Like in the real world of development, it's not always going to be possible to have a clear line on one side is incomplete, on the other side is the other kind of review. You know, it's missing, things get missed, and even in staff review. Again, the reason this gets heightened so much is because of what's at stake, the September 6th. So
right,
the unclearness of it, the ambiguity of where one ends and one starts, and one, that may be fine for 99.9% of what a city reviews. This one's different because vested rights are at stake. So
correct.
Again, which way that cuts will be for the board to determine ultimately. But
Madam Chairman, I have a question.
I'm going to ask a question, then I'll let you ask a question. So did it ever go to the DRC to be the official
No, it did
findings?
not.
It has
No.
not, it hasn't done that yet.
You
right?
are correct.
Okay, that's what I thought, but I just wanted to clarify that.
But I think it'd be helpful to ask why.
Oh, that's true. That's true. Why?
My question is along that line of, if that's the process, where is that information for the developer to find that he needs to attend an open hearing and they're going to get a final decision? How does that happen?
And board member Crossett, sorry.
Yeah, go ahead.
That's the reason why we have 10-9A 509.5, is that a developer can request saying, hey, I submitted an application, a reasonable time period has gone by. I don't know what the status of my application is. I would like to know, is this complete or is it deficient? And put the city on a clock.
But if they haven't voted on it yet, how do they get a response by just asking that question? If once they ask that question, does it get sent to the board at that point at their next meeting and they vote on it then? Is that created that event because they sent you a letter asking that?
So, and I'll just read from the statute. Each municipality shall in a timely manner determine whether a land use application is complete for the purposes of subsequent substantive land use authority review. After a reasonable period of time to allow the municipality diligently to evaluate whether all objective ordinance-based application criteria have been met, if application fees have been paid, the applicant may in writing request that the municipality provide a written determination either that the application is complete for the purposes of allowing subsequent substantive land use authority review, or deficient with respect to a specific objective ordinance-based application requirement.
So you're saying that they've submitted all this information and they have to get to a point where they talk to, I don't know if it's Ryan or whoever in the city, and say, is our application ready to be submitted for vote? I'm trying to understand how they would know.
So they would send a written request saying, is our application complete for substantive review? Then that puts the city on a clock, a 30-day clock to respond. And if the city doesn't respond within the 30-day clock, that application is deemed complete by statute.
The city would acknowledge that that 30 days would have put it past September 6th in this case, correct?
Again, yes, it would have, but they never requested that in this case.
Right, but even if they would have, the city could have taken long enough that it wouldn't have mattered essentially, because the pending legislation doctrine would have applied after September 6th.
Correct. I mean, again, we responded our decision that their application was incomplete within 30 days of them submitting the application itself.
So,
yeah, let me hit one follow-up. So it said, that statute says within a reasonable time. What's the city's position on whether this was a reasonable time?
I believe it was reasonable.
Not the city's response, but the statute says the request by the developer can be made after a reasonable amount of time has passed to allow the city to review the application. The application comes in on August 21st, and there's still some exchange going on the 29th. And then the applicant again submits responses to the red lines on the 5th. When do what's the city's position as to when they should have made the request? When would they have been on notice that a reasonable time had passed where they hadn't received a response from the city, and so they needed to make the request that you outlined in the statute?
So again, we're in the process of redlining. They could have made that request whenever in the process of redlining. They could have made that request after not receiving a second set of red lines. They could have made that request 7 days after not receiving those red lines. I can't speak to reasonableness because I don't have the facts in front of me.
Let me address that a minute if I may. Typically that statute comes into play when you submit an application and you receive nothing back from the city whatsoever. It's crickets, you're not hearing anything, and you send a notice to the city saying, hey, I've submitted my application, tell me what's going on. Is it complete? What's happening? Give me that notice. Here, we submitted it on August 21st. On August 29th, we received back this memo from the DRC, City of Orem, DRC, with the red lines. Again, under the statute, as council suggested, once it's submitted to the DRC, it's deemed a complete application. We get this memo that says City of Orem, DRC. How are we not to know that really isn't the City of Orem, DRC? Orem is, the city staff, whatever the issues of years of not following their statute or whatever, are being phenomenally sloppy with legal terminology and legal rights. We had a right to rely on the fact that this came from the Orem DRC, and based on the email from August 21st, that our application was complete. What they're saying is, well, we sat on this until after the September 6th deadline and then gave you notice it wasn't complete. By then, too late, you're out of luck. Every indication we had was that this application was complete. And in fact, it was. The traffic impact study does meet the requirements of the Orem ordinance.
I was just going to add, on the side from a developer that's submitting plans, that 8 days that it took to get those initial review comments back is really fast. And especially when you look at kind of late 23, there was still a lot of development going on. And I know how busy the staff is and everything that they've got on their plate. So we appreciated how fast that went. We had no reason to send a formal request. And then when we resubmitted those red lines on the 5th, I always try and give cities at least 2 weeks to get through the red lines because I know that they have a lot of stuff on their plate. So to me, reasonable time before I start poking cities to see if they have red lines for me is at least 2 weeks. And then that put us there close to where we got the letter that said your application's been deemed incomplete. So.
May I ask a question? I know council here gave us his definition of vested, and I know our city council. Will you just identify if in your opinion or following ordinances here of Orem, were they vested or not vested?
They were not vested because the application submitted to the city was not complete. It was being redlined. City staff reviews the traffic study, determines it doesn't meet the ordinance. Because they never submitted a complete application, their rights were never vested.
And so I would agree with that somewhat, but if the traffic study does meet the ordinance, as Dr. Perrin testifies that it does meet it, then it would be complete. If it is a complete application, then the rights are vested.
It's the answer I thought I was going to get.
Madam Chair, so I'm not trying to understand if they receive that letter with the DRC on it. Is there a written outline for them to follow so that they know that DRC that was sent to them wasn't really the DRC? Do you have something in writing that says this DRC, part of the DRC that Ryan was talking about, looks at it, and then this group looks at it, and then it goes to the group that votes? I mean, how do they follow the procedure so that they know they're doing that?
So Orem City Code 22-1420C has the approval process, wherein it says the Department of Development Services shall forward a complete site plan request to the Development Review Committee members for review. The members of DRC shall review the site plan request for compliance, et cetera, et cetera. So there it's saying at the first step is Development Services does an internal review of the application. Once Development Services determines that the application is complete, they then forward it on to DRC. That would be the writing, the written notice that this is the process. And again, I think all throughout this, as we're engaged in redlining, they're on notice that their application is still being worked on. It is not deemed complete.
So is no application considered complete?
The application is complete when it is forwarded to DRC for compliance with the general plan review, city ordinances, and then as Ryan said, it is 100% complete once DRC votes to forward it on to Planning Commission. Because DRC cannot forward any site plan application by ordinance to Planning Commission unless it meets our ordinances. So it does not get deemed complete until after DRC votes to send it to Planning Commission by ordinance.
I was going to ask a different question, but I'm noticing here in my notes that you said that it did go to the Planning Commission on September 6th.
No, it never did.
Why did I write that down?
Planning Commission.
Somebody said something about September 6th and the Planning Commission.
The application to rezone this parcel from C2 to PO went before Planning Commission on September 6th, not Holiday Oil's site plan application.
I can't write as fast as you talk, so that's what I had.
I want to point out too, council's now getting a bit inconsistent with his argument. Originally, when he was at the table, he's arguing that an application is deemed complete when it's submitted to the DRC. Now what I just heard him say is, well, it's not deemed complete until the DRC actually submits it and forwards it to the Planning Commission. That is not the legal standard of determining when it is or is not complete. Completion is determined when the items that are required are submitted to the city, the date they're submitted to the city. Now, what he says is, well, when it's submitted to the DRC, we know it's complete. Because it wouldn't be submitted to the DRC unless it's complete. And the DRC goes through the red lines. You get red lines from the DRC, even reviewing a complete application. And this is the 10-9A-509. An applicant who has submitted a complete land use application is described in subsection 1C, including the payment of all application fees, is entitled to substantive review of the application under the land use regulations. That's where you get your red lines. They're doing a substantive review of the application as compared to the land use regulation. So just because you're getting red lines does not mean it's not complete.
Board members, if I could respond just briefly, I don't mean to go tit for tat here, and I won't, but I do feel like I need to clarify. I am not being inconsistent. I'm reading our ordinance. Our ordinance specifically says that the Department of Development Services shall forward a complete site plan request to DRC members for review. Then it continues and it says that DRC shall forward a site plan to the final approving authority only if it complies with the general plan and all city ordinances, resolutions, and policies. So there's a two-step decision-making on completeness. Staff reviews, once they believe that they've got a complete application, it goes for DRC for final decision on completeness. Once DRC votes, then it goes to Planning Commission. And that is where we get the substantive review by the land use authority, which is what is defined in 10-9A-5, 10-9A-509. Because it says first there's a review for form. That is what staff and DRC are doing. Then there's a substantive review by the local land use authority. That's the Planning Commission and the City Council.
So would it be accurate to summarize it this way? That the city relies on that ordinance to support the position that rights do not vest in a development until the DRC votes to send it to the Planning Commission?
That would be the city's argument, yes.
I just have a question about definitions. So, and we've been doing construction at my house, so I've been talking with Cheryl and with Jason and many people at the city about just trying to move our kitchen from where it was originally to the back room that was an addition to our house. It's been a long process. So we've submitted applications. They accepted the application and then they told us, well, this is wrong. So, I mean, so it was a complete application. It just needed to be fixed, or then it needed to be approved. So you keep using the word complete, but I'm wondering if what you really ought to be saying is, well, yeah, they checked all the boxes, and in that case, it was complete, but we didn't really approve it because we wanted a more current traffic study. I mean, is it approved over here? All those boxes, we agree with what they've put into those boxes? Because that wasn't my experience, humble though it was compared to what you guys are trying to do.
So again, I think there's a difference between a check the box review. If we were to adopt a check the box review, I don't believe that 10-9A-509.5 would ever exist. Because if we were just doing a check the box review, that decision on whether or not an application is complete would be done within minutes. Do you have this document that's titled this? Check the box. Do you have a document that's titled this? Check the box. So it's not a check the box approach. It's a look and see, did they submit the required documents? Do those documents comply with our ordinance requirements? Do they provide the information in the form that we require? If not, it is not complete.
But also, I think it's important to note that approval is not synonymous with complete. Complete means you submitted the required documents that meet the requirements of the Orem City Ordinance. It then goes through the process to get to approval. Completeness is not the same as approval. Vested rights occur upon submitting a complete application, not upon approval.
my basic question.
That's why I thought that's why I understood your question to mean, so I wanted to address that. Thank you. Based on, unless there are other questions, we would submit it on that. We would ask that the board consider this and that it overturn and overrule city staff's decision that this was not a complete application and that this should go through the remaining process with the city for approval.
Thank you.
Thank you.
Is there a difference? This could be too simplistic. A difference between incomplete and outdated? I mean, I do believe that there is a difference, but
Yeah.
would it make a difference?
I mean, I think that's the heart of that could be an important aspect of your determination is, the word current. Is it required to be current in order to meet the requirement
of
completeness? Yeah.
Okay.
So I don't know that there's a legal answer to that. That's something you're going to have to kind of grapple with.
Okay.
Is the word current in the code?
It's not. My review of it, of the Orem City ordinance, is that the word current isn't there. There's probably an argument of whether it is or isn't implied, but the word itself, it isn't in the ordinance.
And what would it mean? I had to take the study, do the study today and hand it in today. I mean, what does current even mean? But if it's not in the code, then.
Right, it could be
maybe
2 months,
that's-
6 months. Again, it's hard to draw a line at some point. Reasonable people would probably agree, well, that's not current, but where that line is would be hard to.
Well, and
determine.
all traffic studies would be projected into the future as well, right? So it's current plus or.
Yeah, I don't know how
valid
much
or-
future, I don't know how much future development a traffic study takes into account. Maybe units that are entitled at the time, but I just don't know enough about.
The timeline of 18 months has been
That was
spoken a
going
couple
back,
of times. Yeah.
I don't know how much. So
But-
I think the traffic engineer is saying they try to project out 5 years for a traffic impact study,
Mhm.
a future 5 years of
Okay.
growth.
Other questions that you have?
I move that we go in the other room and talk about it amongst ourselves.
Yeah, just make a motion to close the meeting.
No, no, go.
Well, again, are you part of the applicant?
Okay, thank you.
So,
Please state your name, please.
Mike Wagstaff, I'm the president of Holiday Oil and my family owns Holiday Oil. My dad started in 1964, so we're coming up on 60 years of doing this, buying a piece of property, building a gas station, running it, and making things happen that way. And we've worked really hard to make these things happen. And so in good faith, I mean, I know the timelines, I'm not an expert in all of those things, but just to appeal, from my perspective, common sense. We did all of our due diligence on this piece of property. It was zoned the right way. It had an agreement in place to be able to build that. We used our people to communicate with the staff. They gave us every indication that we were able to move forward. We did want to make some adjustments because we prefer to have a car wash, like you've probably seen some of our other locations, change the building a little bit. That was denied. And so we were okay with that because that's why we bought this property, to build that station. So we continue to move forward. At that point, obviously the winds of whatever, all the politics that were going on and so forth. So those things started to happen. And that's why this race began, right? From our perspective, we weren't in any race. This was not something that we wanted to push through. We have many other pieces of property that we were trying to develop, but because of the things that were happening, that's the only reason this has come to such a crazy, and from my perspective, crazy head, right, that we're doing right now. But for us, as a family-owned business, this is a huge deal. This is literally probably millions of dollars, right? And this location that we've invested, we'll invest millions more to make this happen. And from our perspective, to see, it feels like some manipulations with, it's just frustrating from our perspective. In good faith, working with the staff, we felt like everything was good, but obviously things change. And so we'd love to continue to work forward and move forward and develop this site and make that work. And so anyway, I just wanted to give my perspective. I appreciate, I feel bad everybody's spending all their time doing these things. But we want to work together with communities. That's really what we do. We are focused on communities, taking care of communities. People come to our locations when unfortunately bad things happen. So
This is a public meeting, and so we can't take comments. I'm sorry. He's part of the applicant. please.
He's the owner. He
He's
has a
the-
right to
He's the
speak.
applicant.
It's not a public hearing. It's not a public hearing.
Okay,
so anyway, we appreciate your time. Thank you.
thank you. Okay, did you want to make a motion?
I move that we, do
Go
we
into
need to
closed session.
adjourn this meeting in order to go and consult?
Well, no, you don't, because you're just going into closed session. So when
Okay.
we come out of closed session, then you'll enjoy, because it's the same meeting, it's just a closed portion of it. Then you'll make a motion to
Yeah.
come out of closed session and then make a motion to adjourn the
I
meeting.
move that we go to a closed session to discuss among ourselves the things that we've been learning from everyone involved, and then come back.
I will second that motion. All in favor?
Aye.
Aye.
That's right. Actually, you could be our hand examiner. You go.
Yeah, so we're there. Thank you for your patience. We have a couple of questions. One is, we wanted to find out if the city did their own traffic study, and if not, why not? Who would be able to answer that?
So the city did not commission a traffic study. And the reason is there's no obligation upon the city to do it. It's discretionary upon the city. But it
Okay.
is a requirement of the developer and not the city.
Okay, all right, thank you.
Can I just add another question to that? When I was on the traffic commission, and it has been a few years, we talked about Geneva, whether we should add more lanes, do whatever. And at that time, the city had done a study and suggesting that that wouldn't need to be done for about 20 years, not even an issue. So I knew at the time that the city apparently does routine studies of traffic, because that's what the traffic
So
department would do, right?
Board member Nelson, I'm not sure I know exactly what you're referring to, but if it was maybe a part of a, master transportation plan review, the city may have commissioned a traffic study in the process of trying to prepare that transportation plan. But again, that would be separate and distinct from a site plan application.
Well, the reason I was asking that was just to find out how frequently the city may be reviewing those kinds of situations, whether it's a formal study or just, looking at current information. Do you know the answer to that? I don't.
Well, again, I think the city does review their master transportation plan on a regular basis, but again, what we're looking for on a master transportation plan is going to be very distinctly different than the impacts of a development that would be submitted as part of a site plan application.
And then does the city have a traffic engineer?
So we have a city engineer, Sam Kelly, and we have contracted, in this case, we would have contracted out with Paul Goodrich, who is no longer with the city, but with a private entity as a consultant to review the transportation study.
Excellent. Yeah.
Or not the traffic study, not transportation study.
Okay.
So somebody from Holiday that's been through this process, could you tell us the experience of getting approvals in Orem City in the past? When you got to this point of submitting an application, what changed? What changed from now to? Yeah, sure. Just so trying to understand what you would think is happening versus what was happening with the city.
Sure. So I was involved with that store on 800 North and 1500 West. I went through the entitlement process with the city, got the approvals from Planning Commission, City Council. So that one, we worked well with the city. The city worked well with us, going through the steps of DRC, getting approvals, going through Planning Commission, City Council and whatnot. But so this one, it's just a little bit different because I think there was a little more pushback because it's in a residential area. But going through the steps, we feel like we haven't been given the due process as other sites that we've had, in the last few years of going through the cities.
Was there communication when it went to the DRC for a vote? Was there communication in the past where you called somebody up and said, hey, is it going to DRC this week?
Yeah, whether we
or
reach
what?
out to Cheryl or Michaela or Jason. I'm trying to think if we did that 3 years ago for our Orem store, but yeah, there's always been good communication back and forth.
Okay, so
And then this one-
there wasn't, you didn't have to send the city a letter to get information.
No,
To
not at
know
all.
where you were in the process or what their decision was.
No,
They were
there's been-
communicating to you.
Yeah, previous one, it was great communication.
Okay. And
So-
is there any rebuttal from the
Can-
city?
Was that communication from them or
It was
two-sided
both. It
or?
was two-sided. Yeah,
Okay.
us reaching out, them reaching out, telling us what was needed, or us submitting additional information.
So did you have communication this time? Did you initiate any communication? I
Yeah,
guess is a
I'd
more
ask when we're
appropriate-
going to DRC, and they would say, get it in by noon on Monday, and we'll get on this week's DRC, and then following up with city.
So you knew that there would be a DRC meeting?
Yeah.
Okay.
Yep.
Okay.
Yeah. Yeah.
The technical meeting or the?
So DRC, I mean, it was.
So
I didn't know
there's
I didn't know there was a technical or other thing. It was just always referred to as DRC.
Mhm. Okay.
So you asked for a rebuttal, Board Member Crossett, is ultimately, yes, there's been open communication between the city and developers in the past, and I would even say here, but again, I would clarify and distinguish communication. The redlining process is still the form review. It's not a decision that the application's been complete. And again, relying on the advisory opinion and even the Utah Supreme Court case is, as you engage in this redlining process, just because you're engaging in redlining doesn't mean there's any vested right. The
Right.
developer is still correcting and modifying that application until it is complete.
And I understand that. I'm just trying to find out if the process changed to where they would have thought one thing because of the communication, because of their past relationship, or what happened there, where the fall of communication came as far as them thinking they were approved and the city saying, no, you're not approved. Because in the past, it sounds like they just communicate back and forth and it was a non-issue.
And I think it was a non-issue because there was never a decision like what has been made. And I think that's what distinguishes this from everything. I don't think the communication has changed. I don't think there's been any real changes procedurally with how the city has processed applications. I think what you're seeing is a distinguishing in the city made a determination that's been different than has been in the past, or at least the outcome is different.
Thank you.
Does the city normally give a developer the opportunity to complete an application?
So again, that would be the redlining process, is to make adjustments, corrections, make modifications. But again, the city always retains that ability to decide whether or not to deny the application for completeness. In this case, the city's determination was the traffic study was more than mere redlining, that the traffic study as it was submitted was wholly insufficient and would not go through the redlining process.
So my question was, does the city normally give people the opportunity, or a developer the opportunity to, if the city believes an application isn't complete, to then go ahead and complete it?
Again, we've engaged in that redlining process with other developers, and I even believe it's been represented by Holiday Oil in the past. We've engaged in a redlining process with them. But I think there's, again, a
I
distinction.
didn't use the word redlining. I asked if the city gives developers the opportunity to complete an application if the city's legal department believes that an application isn't complete.
I think we may be talking past each other. Agreeing to allow a modification or a correction to an application is what I'm referring to by redlining. So have we given developers the chance to modify, bring their application into compliance with an ordinance or requirement by a redlining process? Then the answer is yes.
May I address that?
May he address that?
I'm trying to decide. Yes, if you can be succinct about it, because we don't want to be here forever.
No, I'll be very quick.
Thank you.
In this instance, that in fact happened in the August 21 emails that came from Cheryl. It was an advice that your application is not complete. You need these 2 items, please submit them. And that is typical of what would generally happen.
Thank you.
One more. Sorry.
Just a second, let's ask this other question.
Okay.
Or is this about the same thing?
I just wanted to ask why they didn't submit a new traffic study when they submitted originally instead of the 2020. No, from earlier testimony, you talked about a traffic study should be more than likely updated after 18 months. So that was a traffic study that had already kind of lived its life because it was 2020 and you went to 2022.
The traffic study had already been accepted by the city for this very project as part of the development agreement. That's why it was submitted with this application and not updated.
But based on what you told us, your expert.
The traffic engineer.
Yeah, that's typically what it is it has a shelf life of about 18 months, and then you should update that if it's not already in process. This project is in process though, and so at that point, it would be requested. Typically, you do have a traffic engineer, his name's John Dorney, and he's your senior traffic transportation engineer. He's never seen the study.
But there was never any discussion like maybe we should ask the city if that should be updated.
It's very, as a red line, it would come back as, hey, this is old. I've known John for 15 years. If he saw the study and I just talked to him before this meeting, he hasn't seen it, he would have just said, Joe, your study's old, give me a new one.
Sorry, who's John?
He's your senior, he's Orem's senior transportation engineer.
Is that correct?
Cheryl, yes.
About 6, and he hasn't seen this.
Well, that makes sense though, that if it's only been 6 weeks to him to not be there.
He's
Okay.
actually asked that email it to me.
Just for information. One other question, this is for the city, the letter that was signed by the mayor and or not signed, the letter that was drafted that went out to the neighbors from the mayor and the city council. Who drafted that? We were just curious where that information came from.
So that was drafted by city management from the city manager's office.
Okay. But no signatures or anything like that were involved?
I didn't see any final signed letter sent out.
And we didn't either, yeah, okay. All right, any other questions about that? Was it, do you know who reviewed it or anything like that?
Again, I think, the city manager's office had that sent out as a public service announcement. I would anticipate there had been a conversation between the city manager and the mayor, but to whom all was engaged in that conversation, I cannot answer.
Okay.
So the legal department didn't review it?
We did.
And it went out substantially as you had reviewed it?
Yes, as the legal office did.
Okay.
Okay, thank you.
But again, I'm just going to answer again. This was not prepared as a legal statement. It was not reviewed as an idea as a legal statement to be made as to completeness or not completeness as to an application. This was done as a public service announcement to the neighborhood who was involved in the public hearings.
Okay, thank you. All right. Any more questions?
Yeah. So can you tell us when the city accepted the traffic study? Sometime in 2020, I'm assuming is what you're saying.
Yes, in 2020, it was submitted to the city as part of the process of getting the zoning change and the approval of the development agreement.
Contemporaneous with the C2 zone change in
Yes.
2020.
In 2020.
So then is that typically something that is just piggybacked onto a site plan?
Well, it depends. I mean, on this, Mr. Perrin was explaining, the whole development was in process. So yes, that is typical that would be used, continued to be used if city engineering department would desire a more updated, and it wouldn't necessarily just be related to the traffic study. It could be any item. It could be a percolation test or anything. If city engineering wanted more of an updated study being done, whatever that might be, in this case of traffic, then the city engineer would request that that be updated.
And did they?
They did not. As far as we know, the engineering department never reviewed this traffic study. There's no indication that there's any review by an engineer on behalf of Orem City of this traffic study as to whether it was or was not complete.
So with professional staff not making the judgment that the traffic study was insufficient, is that legally binding?
Well, I don't know that it would or wouldn't be legally binding, but I guess the point is, the determination that the traffic study did not comply with the Orem City ordinances, I think is a professional technical review. That professional technical review was not been done. That's been done by the legal department, but not by a qualified engineer as to whether it does or does not comport with the Orem City requirements.
And Board Member Nelson, I'm going to actually object to this because legal staff worked with Paul Goodrich, who was the consulting traffic engineer at the time in reaching this determination. Mr. Goodrich is not here. It was not anticipated based on council's letter that they submitted as part of their appeal that they would be challenging the deficiencies of the traffic study. If we review their November 10th letter, there was no actual assertion that our statements as to the deficiencies of the traffic study were in question. So Mr. Goodrich is not here. We've not proffered evidence as far as expert testimony to combat Mr. Perrin's testimony provided tonight because it was never in their legal appeal to actually challenge the deficiency claims that we've made.
Well, the appeal is about the completeness of the application. The sole basis of the city saying it's incomplete is a traffic study. So the traffic study is at the very heart of this issue. I think they were very much on notice that that was an issue here, but we've never seen any indication that an engineer on behalf of the city actually reviewed it and came to the determination, the professional determination that that did not comport with the city ordinance.
And again, our incomplete application determination wasn't signed by the legal department, but rather the Development Services Department, which would have incorporated Mr. Goodrich as a consultant on the traffic engineering.
So when was that given to Holiday Oil?
September 20th.
The determination that the application was incomplete was given on September 20th, but there's nothing in there that states as this was reviewed by the city engineer and found to be deficient by the city engineer. There's no indication of that.
And then just to respond also to the claim that it is typical and that this process was already being completed or was still in process is, again, the C2 zone change was in 2020 with different parties in privity to that agreement. Holiday Oil then is assigned the agreement in 2022. 2 years after, no development occurred, no applications, no site plan application was ever submitted until 2023. And so, yes, it would be from Development Services position, need to be updated.
And that determination was made on September 20th?
It was noticed to Holiday Oil on September 20th. It was in process in staff review from the time that Holiday Oil submitted their site plan application on August 21st, in conjunction with city staff review, legal counsel, Mr. Goodrich, we made the determination and then we noticed them up by the incomplete application determination letter sent. I mean, Board Member Nelson, are you asking when, on what date, what time was this decision made? I don't have that. It was a process of working through, reviewing the document and working with staff. I don't have a fixed date or time on when the decision was made. I can tell you when we notified Holiday Oil of that determination.
Well, I'm just grappling with a number of questions. The idea of if it's complete or if it's perfect, whether it's redlined or whether you're giving them a chance to update something, and why we're in a race. Those are the things I'm grappling with, and that's why I'm asking those questions.
Yeah, I'm just letting you know, I don't have a certain date and time. It was a process to reach this ultimate conclusion.
But it's beyond the time that they would have been vested, and so that's kind of a snag here in the whole thing, it seems to me.
It is, but again, it's not necessarily on the city. It's, we had noticed up that we were changing the zone. They submitted an application that didn't meet those requirements.
Thank you.
So we're all grappling with quite a few questions and things. So someone would like to make a motion on this? Anybody?
We better.
The motion that we've talked about doing here.
Yeah.
You're going to do that? Oh,
Yeah,
do
yeah.
I need to say more?
Don't we have to go through the rest of the?
No, you can
We need to
finish
make
this
we
item,
need to
make your
a
motion,
on this item.
and then you'll
And
take care of the
we'll-
other two items of
then we'll-
business that are on the agenda.
Yes, no?
All right, try.
Okay.
I'll make a motion that we table this item and reconvene in 2 weeks. In the process that we'll have something written up so that we can review again back here in 2 weeks and then make the decision, the final decision.
I'll second that.
All in favor?
Aye.
Aye. So we have tabled that motion until 2 weeks, which would be December 13th. Does that work on the calendar? We didn't ask that question. While she's looking that up, we will talk about item 4.1. Has anybody reviewed the minutes? You weren't even on the board yet.
I have reviewed the minutes and I move that we approve the minutes.
Thank you. I will second that. I have also reviewed them. The motion has been made and seconded. All in favor?
Aye.
Any opposed? Okay. Item 4.2, review and approve the 2024 meeting calendar. Anybody would like to?
I
make a
have
motion on that?
reviewed that and move that we approve the calendar for
Thank you.
2024.
We have a motion.
And I'll
Is there a
second that.
There's a second. Thank you. All in favor?
Aye.
Aye. Any opposed?
Before,
Yeah,
before a motion to adjourn, just a clarification on what time on
Oh,
the
yes.
13th that you'd
What
like to
would-
convene that meeting. And again, maybe check with the
yeah,
calendars
because
first.
we wouldn't determine that. You would tell us when we would need to be here.
It looks like the calendar is open, so you could do it 5, you could do it 6.
Okay.
5 sounds good.
So 5 as a pre-meeting or
We
as the
wouldn't have a
meeting?
pre-meeting, we could just come
We could
straight to
just
this meeting.
Come straight to this meeting. Perfect.
Yep.
Thank you.
5 o'clock?
Okay. All right. And a motion to adjourn, please.
Don't we want to do a pre-meeting?
We don't need, well, we're going to get the information already.
I don't see
so we
one
won't need
being
to.
necessary.
Yeah.
Yeah.
Okay. I'll make a motion that we adjourn.
I second it.
Thank you. It's been moved and seconded that we adjourn. All in favor?
Aye.
Aye. Any opposed? No. Thank you for being here. You know, before I came on the planning.
Thank you, Ryan.
You're welcome. Thanks for being here.
Sorry for being